Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. No better place to start a Monday than in Miami-Dade because I know some stuff went on down there over the weekend. So let's check in with Mindy Glazer.
X is next. Anybody see Mr. Wicks?
We already did him, Your Honor.
I did. I don't remember. It's a long morning already. We did Mr. Johnson. John Orbetta?
Yes, ma'am.
Where's Mr. Orbetta? Hey, how you doing? Metro West 6. Good morning, sir. You have an arrest warrant from that says Florida COR. What's that, corrections?
He has the fugitive from Broward and he has the fugitive from Florida Corrections.
So you got a warrant from Broward County. I guess that's the next page. That warrant was issued September 11th of 2025. Criminal use of personal identification, criminal use of personal identification, grand theft, violation of probation. No bond on the warrant from Broward. You're going to have to wait up to 15 days for Broward to pick you up. Public Defender's Office is appointed for you. The reset date is November 4th, and that hold from Florida Department of Corrections will follow you to Broward. Have a good day.
That's no fugitives.
What?
Both the fugitive from Broward also. No bonds.
No bond on the warrant from Broward. And also no bond on the warrant, the hold for Florida Department of Corrections. Michael Ezell is next. He's at Metro West 7. Good morning, sir. You have an arrest warrant from Broward County that was issued February 3rd of 2025, not in custody capias for aggravated assault with a deadly weapon. I will appoint the Public Defender's Office for you. Mr. Wilson, do you need me to reset it?
Yes, we could reset it to the PM, Your Honor.
I'll reset your case in the afternoon to see if what?
I was willing to waive extradition.
You don't waive on this. The in-state warrants, you're going. You don't waive or contest.
Oh, okay.
But he's going to try and see if Broward will agree to a bond. So I'll reset your case to
right. I also have a lawyer as well, ma'am.
You have a lawyer?
Yes, ma'am. Lawrence Hashish.
You can afford a lawyer?
I already have a lawyer. I just
good. I'm not appointing the Public Defender's Office for you then. Call your lawyer. I'm not setting it in the afternoon. If your lawyers agrees to get a bond for you, they need to come back and tell us. Otherwise, you'll go to Broward within 15 days. The reset date here is it's November 4th. They usually come once a week. You shouldn't have to.
Okay, so a question. So if the public defender can
No. You got a private lawyer, call him up. Mr. Hashish, he's a good lawyer. Give him a call. If he's able to get a bond for you, he can come back and speak to the state or come pop in and let us know, and we'll give him a sample order.
Can I ask a question? Does that hold me for extradition?
You're held no bonds until you're either going to get a bond now if Broward agrees to one, or you'll go to Broward sometime this week and the judge will give you a bond.
Okay, so I will be getting extradited if I didn't get a bond. That's all I have.
Correct. You're going to go to Broward probably sometime this week since it's Monday.
Okay, thank you very much, ma'am.
Have a good day, sir. PD's not appointed. Next is Jeremy Souvenir.
Yes.
Hey, he's at Metro Pretrial on Zoom.
Are you resetting Mr. Ezell?
No, I'm not resetting him. That's a private lawyer. He's not in court, so it's reset November 4th. He'll come in and we'll have to recall it. Mr. Souvenir, good morning. You were at a warrant from Broward, issued January 21st of 2025. No-show capias, aggravated fleeing or eluding a police officer, driving with a license suspended. No bond on the warrant. Mr. Souvenir, here at Metro Pretrial. Raise your hand, they'll see you. Okay. So there's no bond on the warrant. You're going to have to wait up to 15 days for Broward County to pick you up. The reset date is November 4th to make sure you get transported there. Have a good day.
Okay, I think I missed the court date. I already bonded out on that charge, but I missed the court date.
Gotta go see him. I don't have any information other than that you missed court and they want to see you in Broward. Okay.
Okay.
Just talk to the judge once you get there. Have a nice day.
Right. Thank you.
Thank you. Jose Alfonso Gil. Is he a TGK?
Yes, he's coming now, Your Honor. He'll need an interpreter.
Good morning, sir. Do you speak English?
No, español.
Spanish, please. You have an arrest warrant from Broward County. The warrant was issued September 16th of 2025.
Buenos días, señor. Usted tiene una orden de aprehensión del condado de Broward. Esa fue emitida el 16 de septiembre de 2025.
The charge is violation of probation.
El cargo es quebrantar libertad condicional.
I will appoint the Public Defender's Office for you.
voy a asignarle los abogados de oficio.
It says violation of probation and also grand theft.
Dice quebrantamiento de libertad condicional y también robo mayor.
So there's no bond on the warrant. You're going to have to wait up to 15 days. Actually, it says total bond ROR. What do you have corrections?
I have ROR.
Looks like the judge in Broward's agreeing for you to be released, but you better make sure you keep all future court dates in Broward.
Señor, parece que libertad bajo palabra le están dando en el condado de Broward y están de acuerdo en que usted sea liberado, pero tiene que usted presentarse y seguir con todas las audiencias con ellos.
All right, so you're released on your own recognizance. Make sure to keep all future court dates and he should be released. So you want a reset date or no? You don't need one. He's getting released.
It just said he's a B-Fox. That's why he had to come to you first.
Oh, I understand. Have a nice day.
El señor va a ser liberado entonces, asegúrese de ir a todas sus audiencias futuras. Tenga usted buen día.
Matthew Williams is next. Good morning, Mr. Williams. You have an arrest warrant from Broward County. The warrant was issued on November 7th of 2024. You owe child support, cash purge of $2,047. You also have, so that's only cash, and then you have another warrant for driver's license suspension. So I'll appoint the public defender's office for you. The driver's license warrant has a bond of $5,000. So it's $5,000. You can pay, I guess, hire a bondsman for that one, but the other one for child support is $2,047 cash. So I'll appoint the public defender's office for you. If you're able to post that cash purge of $2,047 and a bond of $5,000, you can get out of jail. If you don't have any money to pay those, you'll have to wait up to 15 days for Broward County to pick you up. The reset date here is November 4th to make sure you're transported. They usually come once a week. You don't have to wait that long if you can't pay it. Have a good day.
All right.
Thanks. Next is Ronaldo Meza Guzman. He's at Metro West 8. Good morning.
Yes,
sir.
ma'am.
English okay?
English fine.
Thank you, sir. You have an arrest warrant from Collier County, Florida. The warrant was issued on May 28th of 2025. The charge is no valid driver's license. I will appoint the public defender's office for you. Your bond is $2,000. If you're able to post a $2,000 bond, you can get out of jail. If you don't have any money to post a bond, you'll have to wait up to 15 days for Broward County to pick, for Collier County to come pick you up. The reset date is November 4th. Have a good day.
Yes, ma'am. You too. Thank you.
Marcos Rodriguez, he's at Metro West 10. Good morning, sir. Do you speak English?
Morning, yes, I
Good
do.
morning. You have an arrest warrant from Collier County. The warrant was issued on October 6th of 2025. The charge is violation of probation. I will appoint the public defender's office for you. There is no bond on the warrant, so you'll have to wait up to 15 days for Collier County to pick you up. The reset date here is November 4th to make sure you are transported there. Have a good day.
Thank you.
Thank you. Next is Frisnet Philippe. Mr. Philippe's at Metro West 2. Good morning, sir. You have a
Good
warrant
morning.
from Orange County. The warrant was issued on October 9th of 2025. The charge is battery.
Judge.
What?
I speak Creole, Asian Creole.
Oh, I'm so sorry. If you wait, we'll get you a Creole interpreter.
I'll
Thank-
request one, Your Honor.
Okay, we'll pass it for a Creole interpreter. Then we have Gregory Cherubin. Is he here?
Bond out.
Bond out. Aaliyah Fonseca.
TGK.
Excuse me, you talk to me?
No, I'm waiting for a Creole interpreter. Just wait a minute, please.
All right, thank you.
Thank you. I'm calling other cases while we wait. Do you have Aaliyah Fonseca? Any private lawyers here that need cases at attorney? Let me know. You can raise your hand on Zoom and type the name of the case you're here for too, if you're an attorney. Was she taking a long way? Hello, good morning. Hi, Miss Fonseca. You have an arrest, is English okay? Yeah. You have an arrest warrant from St. Lucie County, Florida. The warrant was issued on September 16th of 2025. The charge is failure to appear in court for allowing an unauthorized person to drive your vehicle, I guess. So I will appoint the public defender's office for you. Your bond is $10,000. So if you're able to post a $10,000 bond, you can get out of jail. You would do that in Miami. If you don't have any money to post a bond, you will have to wait up to 15 days for St. Lucie County to pick you up. I don't know, Mr. Wilson, it's a lot of money. Do you want to see if they'll agree to lower it? I don't know what to tell you. Do you have money to post a bond, ma'am, or no?
No, I don't. But I did just want to mention that I did go to court on the day that it was issued, but I guess they never let me into the Zoom meeting. But I had like the proof of like emails and screenshots of me being.
What do you mean they didn't let you in the building? What time did you get there?
No, it wasn't in because okay, I had sent an email the day prior to my court date saying that I don't live in Port Lucie, I live in Homestead, so I wouldn't be able to commute. So I got an email back saying that it was fine, that I could do it over Zoom, and they sent me the link. And I joined the link the next day when I had court, and they never let me into the meeting. And I was sending emails all morning. I tried multiple times to get in, and no one let me in.
Mr. Wilson, you want to reach out to them?
Oh, yes, sir.
And I also have proof if needed that I was there, and I did send out emails asking to be let into the Zoom meeting.
All right.
And no, I don't have money for the.
No, I hear you. You want to see if they'll agree to release her? I'll set it in the
I
afternoon.
don't have.
Oh, yes, sir. Yeah, I'll even up there, please set the DM calendar.
Well, I can resit it in the afternoon and see if they'll agree. Or if you send me the name of the judge and I have time, I'll call that judge.
Yes, Your Honor.
Do you work or go to school?
Yes, I was working at Walgreens. I was a assistant manager.
Are you still working there?
No, not at the moment.
So what do you do now?
I was getting a new job, but I just got arrested, so I probably missed that opportunity to get
All right.
a job.
I'll set it for the afternoon. We'll see what they agree to. Okay? All right.
Okay.
That's it for the warrants.
Oh,
So
we still.
Yeah, and if we can take one out of turn, number 19, Mr. Myers.
What page?
Page 7.
Well, good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Monday. Looks like she fairly successfully worked through most of her Hollywood Squares situation there. Let's change it up. We'll go to Jefferson County, Texas. Say good morning to Judge Stevens.
You're present with your attorney, Mr. Eckert, and the state's attorney in cause number 23-41506. I understand the defendant is going to be entering a plea today to this indictment. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
We do, Judge.
In summary, this indictment alleges, sir, that on or about May 8th, 2022 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with the use of a deadly weapon, namely a firearm, by shooting the complainant. Do you understand what you're charged with here? If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Agreement has been reached where you would be pleading guilty, sentenced to 12 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily?
Yeah.
That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
Objection.
and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to be press confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this true it states, so help you God. States Exhibit 1 then is made a part of the record for all purposes. Pre-sentence report is waived. So if nothing further to add, I will follow this agreement beyond agrees. I'm going to find then that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second degree felony of aggravated assault as indicted here. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 12 years. And the judgment shall reflect an affirmative finding that a deadly weapon was used in the commission of this offense, namely a firearm. Do you understand? And you would be given credit for all time you have spent in accordance with this case. Do you understand what's happened today, sir?
Yes, sir.
Anything else to add by defense or state?
No, sir.
All right, we are in recess. Thank you.
Still not always. I think this is still listed on my schedule. This is.
And thank you, ma'am. Mr. Kelly, I'll give you all two, Pam. Y'all are ready, right? Is that right?
We are ready to try the case, Your Honor, but Mr. Ham.
Mr. Ham is what?
Yes, Mr. Ham made an offer to us that I have been discussing with my client.
Okay, what
can just,
where's he?
she's outside.
Oh, tell me what's gonna happen.
I've got a judge. My only other issue,
Was it kind of in, it was up at the top here.
I understand, my only other issue, Your Honor, is I've got a hearing in Judge Stetson's court this afternoon. So if we are your number one, I'd ask that we come back tomorrow if we can, but
What is it?
It's a quick enough case, we can do that, and he advised me about the conflict. I can work around that.
About what?
He advised me about his conflict, I can work around that.
Just let me know one way or the other.
I just need a minute.
You got five.
Thanks, Judge.
Six, please.
Did John? There you are.
Okay.
I got a list of stuff for you. Travis Jacks.
Hold off that. I think I was about to talk to you.
All right, well, I'll keep an eye on his court as they sort through things to find the next contestant. Let's go back to Florida, but we'll say good morning to Wade Mercer.
Mr. Thornton, good morning. Mr. Thornton, I first appeared you 1 week ago on a new charge of aggravated battery. I asked that you be brought back today because I wanted to give the state time to communicate with the agency for the persons with disability, because there's already some type of civil commitment or some type of commitment in your case. And I want them to have input on possible placement, because a lot of times individuals in your situation don't need to be in the jail, but we've got to make sure we have somewhere for them to go that's a secure facility or a more secure facility than where they were. We have Miss Ali with us today. Miss Ali is an attorney with the agency for persons with disabilities. Miss Ali, what is your position or your department's position, your agency's position on placement of Mr. Thornton?
Yes, Your Honor. So Mr. Thornton has been a 393.11 client with us for several years. And I'm trying to pull up my notes if I could find them. My apologies. My apologies. My computer is not working with me this morning.
It happens to me too, so.
Okay, yes. So Mr. Thornton has been a 393.11 client with us since 1997, meaning he has been residing in one of our facilities, whether secure or non-secure, since 1997. And when this criminal charge happened, Mr. Thornton was residing at one of our non-secure facilities, the Sunland Center, located in Jackson County. And since he has picked up these new criminal charges, we do agree that he needs to receive some type of additional care for his complex medical needs. And we are willing to accept him to our secure facility as opposed to him remaining in the jail while his criminal case proceeds.
Will the secure facility be at Sunland or somewhere else?
It would be somewhere else. It would be 3DP, which is the Developmentally Disabled Defendants Program.
But they don't have that at all at Sunland, because I'm going to do a condition of no contact with the alleged victim, and I want to make sure there's no problems there.
Yes, those are completely different facilities. They're not even in the same county.
Okay. Mr. McDaniel, on behalf of Mr. Thornton, anything that you want to add?
No, Your Honor.
Mr. Mitchell, what's the state's position?
Your Honor, I've been in contact with Mr. Gill regarding this. He's the assigned ASA to this case, and he is agreeable to that condition.
Okay, so Ms. Ali, I just need to do a conditional release with the sole condition being that he would reside in the 3DP program. That's what you call it, DDDP. You know what you call it, 3DP? That he reside
Yes,
in
Your Honor,
3DP program?
I did prepare a proposed order that I'm happy to share with Your Honor. And so basically what I have it listed as right now is just an order transferring him from the jail to the secure facility. Your Honor is welcome to fashion it as a conditional release, whatever you would prefer. My concern is I'm assuming that this case will probably go the 916 route with getting competency evaluations completed. So him being transferred to 3DP will probably just speed up the process of where he inevitably will be if he's deemed incompetent to proceed.
Thank you. Mr. McDaniel, anything else to add?
No, Your Honor.
Does Mr. Thornton have anything he would like to say?
No. He's fine, Your Honor.
Okay. And Mr. Mitchell, anything else?
I just sent you that copy of the proposed order.
All right, so I'll take a look at that after court and go ahead and make any changes and get that signed. I'm going to sign the order, Mr. Thornton, transferring you to that program. That's going to get you out of jail and get you back to Agency for Persons with Disabilities, Mr. Thornton. And that'll happen sometime today, I'm anticipating. Mr. Thornton, Mr. McDaniel, any questions for Mr. Thornton or Mr. McDaniel on his behalf?
No, Your Honor, we're fine.
Ms. Ali, anything else?
No, Your Honor.
Now, as far as his court date, Mr. Mitchell, I'm going to assume the state doesn't want him coming back. Has the state filed information?
Let me check real quick.
I'm assuming they don't want him being brought back from program just to have an arraignment done.
Give me a second. It kicked me out of my VPN.
If he's already filed, if the state's already filed information, I'll just go ahead and arraign him today, and we'll get that out of the way and get the public defender's office appointed if there's no objection.
I mean, I wouldn't have an objection, but I got to double check right quick.
It's only been about 7 days, so the state may not have had a chance to file information yet. They have not. So just Miss Ali, Judge Garcia will decide what to do with his court date. Normally his court date would be November the 4th. So Mr. Gill, Mr. Mitchell, I'm going to ask that you communicate with Ms. Simpson, who is in that email chain that you just sent me, and about the possibility of bringing him back. I'm assuming no one wants to bring him back for an arraignment. Maybe they can do it remotely by Zoom. I can't do it today because there's no information filed.
I got you.
So Ms. Ali, the state and defense and Judge Garcia will figure out when his next court date is. Mr. Thornton, you're going to be transferred hopefully. Will that happen today, Ms. Ali?
I'm not sure, Your Honor. The facility is pretty close to Jackson County, so either today or tomorrow.
Okay. All right. I'll sign the orders right after the first appearance. Thank you for appearing, Ms. Ali. Mr. Thornton, I wish you the best.
Absolutely. Thank you.
All right. Mr. Gill just came in. He may have something to add.
I would propose.
Let them hear you. I want to make sure they can hear you.
Judge, I would propose that the state is intending on filing information. If we can maybe bring him back tomorrow, have him arraigned tomorrow, and then we could consider the conditional release at that time.
Mr. McDaniel, any objection to that? That saves them from having to come back. And the second thing it does, it gets the public defender's office involved so that they can file a motion for evaluation if they decide to do that.
Correct. Yes, Your Honor.
Mr. McDaniel.
I don't have any objection to that, Your Honor. I'm sure,
Ms. Ali.
he'd like to go home someplace, but that's fine.
Ms. Ali.
No objection, Your Honor.
So go ahead, Ms. Ali, if you will go ahead and prepare your people to do the transport tomorrow, tell them it's coming. And then I'll see it first appearance tomorrow. Mr. Gill's going to have the information filed. I'm going to get you arraigned. You're still going to go tomorrow. It's just you'll go after having a lawyer appointed and not before. So I'll see you in the morning, Mr. Thornton.
Thank you, Judge.
Thank you, Mr. Gill, for coming over.
Thank you, Judge.
Ms. Ali. All right, we do have one other case that has friends or family here, and that is State versus Johnny Carroll. Johnny Carroll.
And Your Honor, this is the alleged victim in this case.
Thank you. He's also, you're right.
Brother-in-law, I think.
Mr. Carroll, good morning. Mr. Carroll, you're here for first appearance accused of one count of battery. Your brother-in-law, who is also the alleged victim, is in the courtroom. And sir, if you want to come on up, please, I know that you want to be heard. Mr. Carroll, you've been charged with one count of battery. There is probable cause in the complaint. I've read the complaint. And you are Mr. Bates?
Yes, sir.
Mr. Bates, you're Mr. Carroll's brother-in-law and the alleged victim, right?
Yes, sir.
So Mr. Mitchell was telling me, or you were telling him in the courtroom, and I heard you that you're wanting to have contact with him. Is that right?
Yes, sir.
Tell me the living situation, because I'm concerned about him going back there.
We moved him down here about 2-3 weeks ago to help him find a job in Florida, and me and him didn't get along. It was just a little disagreement, and it escalated into the violence.
Okay.
So
What about, so your wife is his sister?
sister.
All right.
Yes, sir.
And so what are you asking me to do? Are you wanting him to come back to that house?
No, sir.
You're not wanting him to come back there. You're just, what are you asking me for then?
No, see if we could drop the charges and have have like contact, but no contact with me, but still with his sister.
Okay, you just, I'm just concerned about letting him go back to that home.
He ain't coming back to home.
Okay, does he have somewhere else to live on a
Yes, sir.
temporary basis? Where would that be?
That would be in Alabama in Clayton County with his mother.
Okay, so let me go over his criminal history, because I looked at it this morning. The Florida history wasn't bad. The Alabama history was long.
Yes, sir.
Most recently in 2022, theft in the third degree 2 years ago, 3 years ago. Let's see what else it's got. Looting a police officer, shoplifting in 21, shoplifting in 20, assault in 19. Was anybody injured in the current incident, sir?
No, not physically. It's just I hit a pickup truck in the process, and that was it.
Complaint says you were trying to get away from him and you backed into a pickup truck.
Yes, sir.
All right. Thank you. Let me see if the attorneys have any questions for you. Mr. Mitchell, any questions for the alleged victim?
So you say you don't want him coming back to the house. Is that where you live with his sister, who is
My wife.
your wife? But you still want to have contact with him?
Yes, sir.
Telephonically, in person, specific?
On the phone.
On the phone? Okay. That's all I have right there.
Mr. McDaniel, any questions?
No, Your Honor, nothing.
Thank you for coming. You can have a seat back in the audience. Mr. McDaniel, my concern is his criminal history. This gentleman was in such fear that he was trying to leave the yard so quickly, he backed into another vehicle, and his criminal history is not good at all. So I don't have a problem with them having telephonic contact. I don't know that means I'm going to grant a conditional release because of his criminal history, but I want to listen to the attorneys before I make that decision. Mr. McDaniel, anything on behalf of Mr. Carroll?
Your Honor, I think you have it all in front of you. He's currently not working, it sounds like, so I don't think I have anything additional.
Mr. Mitchell?
Nothing additional.
Mr. Carroll, I'm going to set your bond of $2,500. I'm going to put a condition of no in-person contact with the alleged victim and no contact with that property. So, Mr. Carroll, you post the bond, you'll be released. You can post cash or surety. You can go through a bondsman if you wish. You just cannot go back to that property. And then obviously the state will consider the request to drop charges. Mr. Mitchell's office will make that decision. If they drop the charges, then the no contact condition will go away. But as of right now, they've not even had a chance to review that. You'll get a chance to use the phone in a few minutes, sir, to try to post the bond if you go through a bondsman. And if they charge you 10%, which is kind of an industry standard. If they do, it'd be $250 to get out of jail. Just can't go back to that property. Mr. Carroll, do you have any questions, sir?
No, sir. Judge, my only question is the sister gonna be paying the bond? I guess I'm thinking she's gonna be paying the bond. I would, so I don't know.
He's shaking his head. The alleged victim is shaking his head no. Is there an objection to a cash bond?
I've got no objection to a cash bond.
Mr. McDaniel, Mr. Mitchell's not objecting to a cash bond. Does Mr. Carroll prefer a $250 cash bond?
Yes, Your Honor.
Yeah, $250.
$250 cash bond, okay? And the advantage to that is if the case is dismissed, if it's dismissed, the bond is returned to whoever posted it. Mr. Carroll, wish you the best. We do need to give him a court date. I'm sorry. Thank you, Don. When would that be? December the 1st at 9 a.m. for your court date, Mr. Carroll, if this case is still pending. Thank you for coming, sir.
We finally got our December cases back in December.
So we have no one else in the courtroom. Mr. McDaniel, friends or family, that is. Let's go back to the top of the list, which is Royce Peden. Actually, I need to see Mr. Peden and Shelby Cook. Nope, I'm sorry, I'm wrong. They're not the same type of case. Mr. Peden, you're here because you're accused of, you have an out-of-county warrant out of Calhoun County. I took a look at it. It's a seller controlled substance warrant with no bond on it. Mr. Peden, what that means is when you get to Calhoun County, they'll go to a first appearance there. That judge will determine if you're entitled to a bond, and if you are, he or she will set you a bond. But right now, you've got no bond. Mr. Peden, I never know when the transport's going to take place. It's Calhoun County. It's right next to us. It could be tomorrow. It could be today. But the next couple of days, you're going to be in Calhoun County. You go to another first appearance. Mr. Peden, do you have any questions? All right. Wish you the best, sir. I've already seen Johnny Carroll. The next case in is Corey Hunt. Mr. Hunt, good morning. You're here because you've been accused of one count of driving under the influence. Mr. Hunt, there is probable cause for the charge in the complaint. And Mr. Hunt, I see that you have very little criminal history, almost nothing, maybe one charge. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney today.
Your Honor, I spoke to Mr. Hunt. He's going to plead of no contest to the charges listed. You understand he'll be adjudicated guilty, 11 months, 29 days probation, $1,078 in fines, 50 hours of community service, DUI school, AA counseling as directed by probation, minimum driver's license suspension, and stipulation of less than 0.15 blood alcohol content. He has signed his jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
That is agreeable with the state.
Mr. Hunt, did you hear that agreement? Mr. Hunt, did you hear that agreement?
Yes, sir.
Any questions about that agreement?
The only question I have was about, he just answered it.
Okay, so is that the plea you would like to enter, Mr. Hunt?
Yes, sir.
Mr. Hunt, I'm going to accept your plea of no contest to driving under the influence to less than 0.15. As agreed, I'm going to adjudicate you guilty of that offense. I'm going to sentence you to 11 months and 29 days probation, court costs and fines in the standard statutory amount under county and state law of $1,078 with the standard conditions required by Florida statutes, which include substance abuse counseling at least once per week, 50 hours of public service work, DUI school. I do recommend the minimum driver's license suspension. Mr. Hunt, if you choose to do NA or AA, then we're going to limit it to 12 classes. If you choose to do private counseling or group counseling, they'll determine the number of classes you go to. Mr. Hunt, what we're going to do next, in just a few minutes, they're going to let you use the phone in case you want to set up transportation with friends or family. After you use the phone, you'll be brought to the courthouse because that's where the probation office is at. You'll meet with one of the probation officers, probably will be Mr. Goodson. Mr. Goodson will go over the terms of probation with you, give you a copy of all the rules in writing, answer any questions you have, and then you'll be free to leave. If you do call friends or family, you can tell them that you can be picked up at the courthouse in 30 to 45 minutes. That's when you'll be through being instructed, Mr. Goodson.
Is this his first DUI?
It is.
So
yes.
We started a new, if he enrolls in DUI school within 60 days, that would satisfy counseling, correct?
Yes. If you enroll in a DUI school within 60 days, that will satisfy your counseling component because that school is 16 hours, which is more than I'm going to require you to do. Now, some people financially can't make the DUI school work within 60 days. And if that's the case, then you just start counseling. But if you enroll in the DUI school, I'm not going to make you go to their 16 hours and then more counseling. That's going to satisfy the counseling. Any questions, sir?
No, sir.
We'll see you at the courthouse in a little while. Thank you, Mr. Goodson. Next case we have is Brandy Sessions. Ms. Sessions, good morning. Ms. Sessions, you're here because you've been accused of one count of battery and one count of cruelty towards child. It's also known as a third-degree felony child abuse that you're accused of. Ms. Sessions, there is probable cause for the charges, ma'am. Ms. Sessions, I took a look at your criminal history, so I'm somewhat familiar with that. And ma'am, let me see if the attorneys have any additional information before I address your bond status. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Ms. Sessions, I'm going to set you a normal bond I would set for these charges, ma'am, which is $5,000 on the child abuse felony, $2,500 on the misdemeanor battery, $7,500 bond, ma'am, cash or surety. Ms. Sessions, let me take a look at one thing here. That Mr. McDaniel, Ms. Sessions might be a placement option somewhere on a conditional release. Her criminal history is not horrible, but as of right now, I don't know that she has a place to go. If that changes, Mr. McDaniel, and you want to request some type of release, I certainly will consider it. But right now, what I'm going to do today is set that bond. Ms. Sessions, do you have any questions? There will be a condition of no contact with the alleged victim. That's why she doesn't have a place to go, at least temporarily.
Judge, at this point in time, she don't have any other place to live. I know that I recall the last case I had with her, it was, the wife and, the wife had come down from South Florida, was living in her apartment. So I suspect that's where she's at now. And I don't think she has no place to live right now.
Okay. The criminal history is not, it's not horrible. So if that changes and you get a place to live, let me know and I might consider a conditional release. Obviously, I'll give input to the state before making that decision. In the meantime, you've got the right to post the bond. I wish you the best, ma'am. We also need to give her notice for a court date, which will be November the 4th. November the 4th at 8:30 a.m. will be your court date in front of the circuit judge. I wish you the best, ma'am. The next case is Scotty Thornton, which you've already seen. That brings us to Shelby Cook. Mr. Cook, good morning, Mr. Cook. You were brought back today. I think a judge held you 7 days to see what happened with a violation of state probation. That warrant was submitted. It took a while for whatever reason. It was submitted late last week. So I signed it this morning, which is the agreement Judge Garcia and I have in these late submissions for me to go ahead and review it. So I need to first get that warrant out of the system. There's a no bond warrant in your case, Mr. Cook. So I'm going to ask Sergeant Applewhite to serve that warrant. And then we're going to go forward with the arraignment process. Sergeant.
Thank you, Judge. Are you Shelby Andrew Cook?
Yes, sir.
Okay. And is your date of birth February 23rd of 96?
Yes, sir.
Mr. Cook, as Judge Mercer mentioned, I have a copy of the warrant for your arrest for violation of probation. The basis for the violation of probation is a new law violation. Consider yourself served on this warrant, and a copy will be provided to you sometime later today.
Thank you, Sergeant. So you're going to get that today. The reason we're doing that is I don't want you to get picked up 2 weeks or 2 months from now. I want that warrant out of the system, Mr. Cook. So now let's move on to the arraignment process. If you want an attorney appointed to represent you in that VOP, we're going to go ahead and get that done today so I can get a lawyer working on your case. Would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent you. Listen to Mr. McDaniel, and then we'll see if you have any questions.
Your Honor, also have Joe Harris, who has violation of state probation warrant also. We're going to plea of not guilty on both the cases. Asked to set these on November 6th court docket, and I advise them both, Mr. Green, to speak with them prior to that hearing.
Thank you. And I missed Mr. Harris. You're right, Mr. McDaniel. I should have seen him at the same time. Mr. Harris, you want an attorney appointed also?
Yes.
All right, we're going to show that same appointment then. Mr. Mitchell, anything?
No, Your Honor.
So you both will see Mr. Green before your court date. Mr. Cook, yours may be a different attorney because you've got a new charge. So sometimes, usually the Public Defender's Office gives you one attorney instead of two, but we'll see what happens with that. Mr. Cook, do you have any questions?
No, sir.
No questions? Mr. Harris, do you have any questions?
No, sir.
All right, gentlemen, wish you the best. Kenneth Jimenez. Mr. Jimenez, good morning. You're being brought back today. You first appeared on a new battery case. It looks like you were already out on bond out of Washington County. I think I asked the state to notify Washington County of the arrest and see if they were going to file anything. I have not, there's nothing in the file showing they filed a motion to revoke bond at all. Mr. Mitchell, any input?
We made contact with her, and I think even John even emailed her too, but we haven't heard nothing back regarding that.
Is that, when you say her, you mean the Washington County?
Yes,
ASA?
yes, ASA Ford.
Mr. McDaniel, anything?
Nothing, Your Honor. I did, like I said, I did let them all know, and I think Jake did also. They said they were gonna look at it and make a determination, so.
So, Mr. Jimenez, I'm going to release that hold. They've had a week and they've not even filed a motion to revoke your bond. I'm going to assume they're not. But just because they didn't do it within a week, that's not a state law. That's just a time limit. We asked them to do it within that time period so that you don't post bond and then go right back to jail. That is possible. What I'm saying is you could post bond, and tomorrow the state attorney's office may be filing a motion to revoke your bond in Washington County, if that's Mr. Mitchell.
There was a statement of surrender form that was filed.
Oh, yeah, his bond has
last
been
week.
surrendered. I did notice that upon the arrest. I forgot about that. But upon his arrest, his bond's been revoked, the bond. So he's going to have to repost that bond in Washington County if he gets out.
Huh.
Okay, let me take a look at that.
It's the first thing that pops up when you look them up on CSIS.
What's that case number?
25262 CF.
I didn't see that. I was looking for anything filed by the state and there wasn't anything. So I didn't even pay attention to other stuff. All right, so, well, that's strange.
That's strange.
It was done really fast too. I think it was like the day after the arrest. I remember when I looked at it.
All right, so here's what's happened. Your bondsman in the Washington County case, when you got arrested, they came off your bond. Basically what they say is that they're saying that you had a condition of your bond not to be charged with a new crime. You were charged with a new crime and they're no longer responsible for your bond. Normally when that happens, the court then reissues the bond for the same amount. You've still got the right to post that bond unless it's revoked. In this case, there's no warrant yet. And that was done on the 13th. Today is the 20th. So I really don't know what the deal is over there, but you have the right to post bond here. I'm going to ask the jail to check with Washington County. If Washington County says that you've got to post bond for them, then you've got to post bond for them. If Washington County says that you don't have to, then you're going to be released here and you'll deal with that at a later court date. Sooner or later, they're going to issue a warrant in Washington County. They may not do it until your court date, but they technically surrendered the bond, but the court hasn't issued a warrant there. So I don't know if the judge knows that this bond has been surrendered. That's my guess. But you've got the right to post bond here. I'm not going to hold you for Washington County unless the jail verifies that they want you. Any questions, sir?
No, sir.
All right, wish you the best.
Thank you.
Larry, yes, sir. Larry Booth is next. Mr. Booth is coming up in 24-752 CT. Mr. Booth, good morning, sir. You entered a plea admitting to a violation of probation. I believe it was last week. I asked the jail to hold you for about a week and see if you could post the purge. I said it was financial only. There may have been one other condition, like not getting a license or something, but it was primarily financial. And normally with financial violations, I set a purge amount, as I did in your case. The sentence, I think, was 30 days in jail with a purge of a couple $100 perhaps. And you've not been able to make that purge. So the jail brought you back up as I had asked to see what the state's position was. Mr. McDaniel, anything on Mr. Booth before I hear from Mr. Mitchell?
Nothing, Your Honor.
Mr. Mitchell. Is there an objection? Is there an objection to me
That's what
changing it from a 30-day sentence to a time served sentence?
That's what I was making sure. This was the one you sent to all of us earlier this morning. I have no objection to a time served.
So, Mr. Booth, the plan was for you to make the purge. The purge amount was the court costs and fines you were ordered to pay originally. It's apparent you cannot do that. You've been in jail a week. I think everyone agrees that you've been punished sufficiently. Is it a week or 2 weeks? I think I asked them to be brought back up in a week, Mr. McDaniel.
I don't know why he didn't get brought back up. It's been 2 weeks.
He come back one time, but it wasn't long enough yet, so.
Okay, it's been 2 weeks, but that's all right.
I think I said 7 days. So we need to figure that out.
It was 14 days ago we had him. We seen him 14 days ago, so, I think it was
Monday, he was gonna come back, but it wasn't enough days yet.
Monday before that, we'd seen him, I guess. That was the last time we spoke around. Yeah, we seen.
The last time I had him on the docket was the 14th, I think it's, no, the 13th. We did see him a week ago.
Yeah, well,
No,
it's
we
been
didn't
1 week.
No, we didn't see him. We said not to bring him up.
Oh, yeah, his name was on there, but we never saw him, I don't think.
Corporal, when was he first appeared on this VOP? Sergeant service in there.
10/6.
Okay, so I asked that he be brought back when he had served 1 week from then. So that'd have been the 13th. Instead of doing that, the jail brought him back up like the 9th or 10th. And I said, it hasn't been long enough. I asked for 1 week, not 1 week, including his prior game time, 1 week from this arrest. So he should have been brought up last Monday, and I'm not seeing him till today. Am I right on all that, Corporal? Sergeant?
He was brought back up on the 13th, but we were told that it wasn't enough days yet.
They bring him back on the 13th. I'm not sure what happened, but I mean, he was supposed to come back on the 13th, but I don't know what happened with it. He was on the 13th docket, but what happened, I don't know.
No, something's not right with that. I'm gonna figure it out though. What day of the week was the 13th though?
Monday.
So his first appeared on the 7th.
The 13 days ago.
Bring back up 10/13. Sergeant, I don't think he came back up the 13th. I think he came back up like the 9th or 10th.
No, sir. We had him on the list last Monday on the 13th. And I don't remember if I got a message or a call from you that it hadn't been 7 days yet or something. So you said you didn't need to see him and to bring him back up later in the week. And that was my fault for not having him brought up later last week.
Okay. So, Mr. Booth, I apologize. You were supposed to be brought up after you'd been there 1 week on this case. The first time they brought you up, you had been there 1 week, counting 5 days before the VOP. You'd only been there 2 days then. And I said, no, he needs to come back up in 1 week. And obviously that didn't happen. So I'm sorry for that. Regardless, I think the appropriate thing to do, given the type of violation and Mr. Mitchell's agreement, is to change the sentence from 30 days to time served, which is what we're going to do. The amount of the civil judgment that you were not able to get paid would just be or the amount of the fine you're not able to get paid, just be a civil judgment against you, and you'll be released today as long as you don't have any other holds anywhere, and this case is over. Mr. Booth, do you have any questions?
No.
All right, wish you the best, sir.
Thank you.
Yes, sir. And this is Ms. Polis. Is that right, Mr. McDaniel?
No, I'm sorry. Yeah, Miss Polis is not, she's she's not gonna be able to come out, Your Honor. She's having a mental breakdown, I think, and
so this is the next case then is State of Florida versus Crystal Polis, breach of the peace. I couldn't tell. It looks to me like there was a Baker Act signed 2 days before the arrest. An officer with a different agency goes out there and makes an arrest for breach of the peace. There is probable cause for it, but I can't tell if that officer was aware of the Baker Act and chose not to serve it, or if the officer was not aware of the Baker Act. But it appears to me there was a signed Baker Act at the time the officer went out there and charged this breach of the peace. Is all that accurate, Mr. McDaniel?
except for the part that they didn't know about it. That's all accurate.
They knew about it.
They knew about it.
How do you know that? Because I can't tell from the complaint. The complaint doesn't mention it.
there's a note in that they made that we were to notify JCSO if she was bonded or conditional release.
So they told the jail to notify the sheriff's office that they need to take her, not them. So, it's a standard procedure, standard operating procedure in Graham.
So the agency that made the arrest, can they transport Baker Act orders that are signed? Now, they didn't do the Baker Act, but there was a signed Baker Act order. They wouldn't transport that anyway, would they?
I don't know the procedures on it, Judge.
So Sergeant, you understand what I'm saying? If there's a
Yes, sir.
If there's a signed Baker Act order and Marietta PD comes into contact with a person, I understand if Marietta PD does the Baker Act, the transport's their responsibility, but if there's a signed order from a judge, it's not the police department's responsibility to transport it.
Sheriff's Department.
I think it would be too.
Sheriff's.
So I don't understand why they wouldn't just call the sheriff's department and get it to them and say, there's a Baker Act in effect, why arrest the person? You know, obviously there's mental health issues. All right.
Yes, sir.
So Mr. McDaniel, Mr. Mitchell, is there any reason I can't just do an ROR and let her go on the Baker Act now?
I have no objection to that.
Mr. McDaniel?
That's what I would ask for, Your Honor. Yeah.
Okay. I'm going to give a release on the owner cognizance on Ms. Polis because there's already a signed Baker Act in effect. Let's make sure it's still valid before I do that. It's good for 10 days, I believe.
Correct. It was still valid this morning when I looked at it. It was a 10-day Baker Act order from the 16th. And this happened on late evening of the 17th, early 18th.
It's still good then until the 26th. So I'm going to give an ROR. We're going to let Ms. Polis go deal with that Baker Act. The chief is there now. The chief may have some additional input on who transports in that situation.
So Chief is telling me that they only transfer them to do for the Baker Act if they do the Baker Act. You know, so they would assume that they would bring them to the jail and then the sheriff's office.
When you say they, you mean Marietta PD?
Correct.
Right, so
it would have been
Sheriff Roberts did years back had it changed. So if the agency, like say Marietta Police Department or Cottondale Police Department, if their officer does the Baker Act, then they transport. But
right. What about in this kind of case?
If they don't issue the Baker Act, they don't do the transport.
So I guess my question is, it appears that the thing to do with a judge had already said 2 days earlier, there's mental health issues. It appears that the person should have been Baker Acted, not charged with breach of the peace, the lowest degree crime we have in Florida. So my question is, procedurally, how would Marietta PD get them Baker Acted? Would they bring them to the jail? Would they take them to the sheriff's department and say, y'all got to sign Baker Act? How would they do it so that I can talk to Chief Baggett and see if we can keep this from happening again, but I don't know the right way to make it happen. I know it's not Marietta PD's responsibility. I just don't know how they get them into Jackson County Sheriff's Department to get that Baker Act done.
Yeah, I can't answer that one, how they would, in between their two agencies, how they work that out.
Thank you, Chief.
Yes, sir.
So we're also going to give her a notice for a court date, Mr. McDaniel, so we don't have to deal with that later. Dawn, when do they need to give her a notice to appear for? December the 1st at 9 a.m. Please give her notice for that day, Sergeant, before she leaves. And Mr. McDaniel, if you find out she's still down there, then we'll deal with that on December 1st.
Thank you.
Thank you. Thank you. That brings us to Danielle Sellers. Ms. Sellers, good morning. Ms. Sellers, you're here. Ma'am, you've been accused of one count of breach of the peace, of resisting an officer without violence, and a false ID given a law enforcement officer. I read that false ID statute because I wasn't sure that was probable cause, but a judge had already found probable cause, and there's one part of it that's kind of vague intentionally, I think. So there is probable cause. The judge has already found that. Mr. McDaniel, where do we stand in Ms. Sellers' case, sir?
Your Honor, we're going to enter a plea of no contest to disorderly conduct, resisting without violence. I think the state will probably just end up dismissing the false ID because I don't think she just said she was not Danielle Sellers. You know, we're going to let the court sentence her. And I advise Mr. Sellers, she's probably going to get a year in jail, and she understands that.
Mr. Mitchell.
Put me on the spot with the dismissal of the false ID, but I'm agreeable if she wants to plead to the breach of peace and resisting without violence to dismiss the false ID.
Ms. Sellers, what I would do is if you enter this plea, ma'am, I'm going to set your sentencing for next week. And the reason is I want to give time for you to meet with some mental health programs to see if there's a program that you might benefit from. If there's not, then the only thing I can do is sentence you to to jail or probation. But if there is a program you would benefit from, I would like to know that. And I think you would like to know if there's a program out there that we can find. We'll ask Ms. Corbett with the Sheriff's Department to work her magic and see if she can find a program for you. So I will not sentence you today because I don't know that the year in jail is the right thing to do. If there's mental health issues that we can help. If there's not, then there's not. But if there are, I'd like to know that. If you enter this plea, I'll set your sentencing for next week. You do need to understand, if you enter this plea, Ms. Sellers, you're waiving your right to a trial and you're waiving your right to call and cross-examine witnesses. Do you have any questions about any of that?
No, sir.
And Ms. Sellers, is that the plea you would like to enter, knowing that I'm going to sentence you next week and that's the maximum penalty is a year in jail? Is that what you want to do?
I mean, I reckon that's all there is to do.
Okay. And
But I
just
mean,
don't- I'm not convinced a year in jail is the right sentence, but I'm also, you just got out, Ms. Sellers, so I got to figure out what's going on and try to
Yes,
fix the
sir.
problem if I can.
Yes, sir, and I understand that, and look, I feel the same way you do.
Okay.
Look, I'm
So
fine.
is that the plea you want to enter? And we'll talk more about it next week.
Yes, sir.
I'm going to accept your plea of no contest to the two charges, breach of the peace and resisting an officer without violence. The
Because
second
honestly,
degree
sir.
misdemeanor and just a second, I'll let you say anything you want. It's the second degree
Yes,
misdemeanor,
sir.
and first degree misdemeanor. Mr. Mitchell's dismissing the other charge. We're going to set your sentencing. I don't know that I want to do it on Monday because that may be, is that an arraignment day?
Yeah.
Yeah, so let's do it next Tuesday at first appearance. Mr. McDaniel, do you mind emailing Ms. Colbert and see if she could meet with Ms. Sellers and see if she's aware of any program Ms. Sellers may benefit from? And if there's not, then we'll just listen to Mr. Mitchell and do the best I can. Ms. Sellers, I'm going to see you next Tuesday. And if there's a program that you or your family want her to look at, you need to let Ms. Colbert with the Sheriff's Department know that. She's excellent at what she does, trying to find programs for people that would benefit from them. Now, do you have any questions?
I was just wanting to make sure that that's something she could do, sir, because honestly, I did not commit any of these charges, but at the same time, I understand.
Is this still the plea you want to enter, though?
Yes, sir.
All right, I'll see you next Tuesday, Ms. Sellers, okay?
Yes, sir, thank you.
Now. That last case? No, she's pled. She's pled and I accepted the plea. It's just set for sentencing, so there's no bond. Mr. McDaniel, that's all I had for the morning. Anything else from the public defender's office?
All right, since he's wrapping up, let's go to Bexar County, Texas. 9 to 11% more Judge Boyd is what we strive for here every day, so let's give it a go.
All right, everyone, we're going to go on the record. Court is calling 2020-25 CR 007922, State versus Jesus Suarez Marino. Can I have parties announced for the record?
Rick Payne for the state of Texas. Javier Padilla for the defendant.
And are you Mr. Marino? All right, you're here for a motion to reduce bond, is that correct?
That's correct.
All right, we were here on October 7th. The motion to reduce bond at that time was withdrawn by the defense. The state agreed for your witnesses to be able to appear by Zoom, but you wanted your witness in person, that's correct?
And they're here today, Judge.
All right, state, have you had a chance to review the defense's motion?
Yes, Your Honor.
Are you in agreement to a bond reduction? All right, defense, it's your motion. You may proceed. Do you have any witnesses?
I do. I would like to call Mr. Alex Afron.
Oh, here, sir. I'm right here with your back again.
And counsel, your client does not need an interpreter.
No,
Okay.
my client does not. Just his mother. Good morning, Your Honor.
Good morning. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. State your name for the record.
My name is Alex Afron.
Could you spell your last name, please?
Yeah, A is an apple, F is in Frank, R is in Robert, A is an apple, M is in Mary.
All right. You may proceed.
Good morning, Mr. Afron.
All right, and so if you all could do me a favor, because the court reporter has to hear, and I know it's normal to face counsel. Yes. All right, and if you'll keep your voice up for the court reporter. All right, defense, you may proceed.
We're here on a bond reduction hearing for Jesus Suarez Moreno. Do you know Jesus?
I sure do.
How do you know him?
I am his boss.
Okay. Tell me about your business. What kind of business do you have?
I'm a licensed general contractor here in San Antonio. We've been in business for many years and Jesus was one of my good employees.
Okay. What kind of work does he do for you?
Jesus is an electrician.
Do you know his family as well?
I do. I know his wife. I know his kids. Yes.
Has Jesus been a good employee for you?
Yes, it's been excellent. Yeah.
Would you say he's been dependable,
Yes, absolutely.
reliable?
Yes, absolutely.
If he's granted bond, do you believe he will appear for any court?
Absolutely, he will. Yes,
appearances?
yes.
Do you have any concern or fear that he might flee and not appear for court?
No, not at all.
So if he is released on bond, does he have a job waiting for you?
Yes, I
For him
actually,
with you?
sure, absolutely. The
Yeah.
moment he's out, I'll hire him back right away.
Okay. And how much does he get paid per hour?
He gets paid about $250 per day.
Per day? Okay. All right. And he works how many days a week?
He works about 5 days.
And there's plenty of work for him, so he will be actively employed when he's.
Absolutely, yes.
I'll pass the witness. Sean.
State.
Good morning.
I guess start.
Yeah.
Thank you. You said you're a general contractor?
Yes, sir.
What is, Mr. Slaughter's position?
Electrician,
Electrician. How long has he been working with you?
over 5 years.
5 years.
Mhm.
Any issues with his work during that time?
No, not at all.
Has he ever shown a place to work at any point?
No, he always shows up.
And you said he makes how much per day, sir?
About $250.
$250?
Mhm.
Okay.
Yeah, he's an electrician.
Okay. Does he get paid, cash and give him checks weekly? Or
I'll pay him cash.
Cash?
Yeah.
Cash daily?
Yeah.
Okay. You said he works 5 days a week?
Yes, sir.
Okay. Are you aware of any problems he may have with alcohol or substance abuse?
No,
Has
I'm
he
not
ever-
aware of that.
Has he ever shown, concerns to you about it?
No,
Okay. Are you aware of the charge that's been given?
I'm kind of aware of it, yes.
Are you aware a little bit of the facts about what happened or not?
Not the whole facts, but I've heard about it.
Um, Despite this, you would feel comfortable hiring him?
Absolutely. He's been around my family, my wife, my daughter, my kids. We've been in multiple homes, with multiple females in there. No problem at all.
What type of job site do you guys go to on a regular basis?
We do full rehabs,
So is it residential or commercial?
residential.
Residential.
Mhm.
Okay. These residential homes that you come to, are they occupied by the people or are they gone when you guys are working?
Sometimes they're occupied by people, but majority of them are not occupied.
When they are occupied by people,
Mhm.
is it men, women that are there?
Mostly women,
Mostly women?
mostly women, yes.
The further questions I'll have for this.
Nothing further.
All right, I have a couple of questions. Any objections?
Thanks, Dave.
All right, so these homes that he's in, is there any supervision by anyone else or is he in there by himself?
A lot of times he's by himself. We assign him the job and he's by himself. I've never heard anything negative.
And these hours that he works or would be working with you, are these daytime hours, nighttime hours?
Sometimes nighttime, sometimes daytime. It depends on customers.
And would it be on the weekends as well?
Sometimes on weekends, yes.
All right, thank you so much for coming in
Your Honor.
and thank you for dressing appropriately for court.
Thank you.
All right, you may call your next witness.
I'll call Maria Moreno.
All right, we have an interpreter for this witness, is that correct?
That's correct, Your Honor.
And is the language Spanish?
Yes, Your Honor.
All right, if I could have the interpreter, if you could raise your right hand. Do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Good morning, Your Honor. My name is Catalina Delgado, spelled Delgado, license number 2222.
All right, if you could raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you may lower your hand. All right, defense, you may proceed.
Thank you, Judge. Tell us your name, please.
Maria del Socorro Moreno. Maria del Socorro Moreno.
And are you the mother of Jesus Suarez Moreno?
I am the mother of Jesus Suarez Moreno.
All right. Tell me about your family. How many children do you have?
6 hijos. I have 6 children.
And Jesus, where does he fit in that group of 6?
Es el más chico. Okay. He's the youngest. He's the youngest.
And you have grandchildren, great-grandchildren?
17.
Okay. Now, are you employed?
No.
Espera hasta aquí. If I may, Judge.
That's okay.
She's answering before.
No. So, excuse me, miss. So we either have to use the interpreter or not. Sometimes I know that people are in the middle of a conversation and they know how a question is going to go, but it would make it so easy for the court reporter if you'll wait until the interpreter finishes interpreting and then answer.
Very well.
Right.
Okay.
Gracias.
Let's interpret. Okay. Where was I? Grandkids, 17 grandkids. Okay. Are you retired? Are you still employed?
I don't work. I'm retired.
Okay. And where is your address? Where do you live? If your son is released on bond, would he be living with you?
Sí. Yes.
Have you ever known? You know Jesus is an electrician, right?
Sí. Yes.
Have you ever known him to not show up to work, to skip work, to not call in, any of those things?
No. No. No.
Has he always been good and dependable about his employment?
Yes.
Now, do you know how much the bond is in this case?
Sí. Yes.
How much is it?
123. 123,000.
Actually, it's 125, but that's close enough.
Okay.
All right. Do you know that to post a bond in Bexar County, generally you need 10%?
Sí. Yes.
And in this case, 10% would be $12,500.
Yes.
Can you afford to come up with $12,500?
No. No.
Okay. Would any amount of bond that the judge sets, would that be paid by you?
Sí, la mitad de esa cantidad. Yes, half of that amount.
You would get help with whatever the amount is.
Sorry?
No, you said half. Does that mean that somebody else would pay the other half?
No. Yo pagaría, pero, o sea, me dijo que.
Okay.
I would pay, but you said half. So half would be 12? Half.
Okay. Now, if the judge lowers the bond to say 30,000, would you be able to come up with $3,000?
Yes, sí.
Yes.
Would you be able to come up with any more than $3,000?
Five.
So you could come up with $5,000, meaning the bond would be 50,000.
Yes.
And is that what you would like the judge to set the bond at?
Yes.
And you know that, of course, if you put up that money, you're responsible. So you would you assure the court that Jesus would show up to court for all these future hearings?
Sí.
Yes.
I'll pass the witness, Your Honor.
All right, state.
Yes, Your Honor. My name's so, Jesus is your son?
Sí, sí. Yes, sir.
And you said how many children do you have?
Six.
Okay, how many of those are sons and how many of those are daughters?
Cuatro mujeres y dos hombres. 4 females and 2 males.
Okay, so 4 daughters and 2 sons?
Sí. Yes.
And you're saying if this is the youngest, correct?
Más chico. The youngest.
He's the youngest, okay. What are the ages of your other children, please?
And the first one is 52. La mujer, la primera hija tiene 49. And the second child, my first daughter, she's 49. The next one is 48, the other daughter. The first child, also a woman, she's 46. The next one is 40. And then Chewy, my son, I'm not exactly sure, but I believe he's 34.
Yes, who's your son, 34?
Yes, I believe so. He was born in 93.
Okay, so your oldest son is 52 years old. And you have 4 daughters that are 49, 48, 46, and 40. Okay.
Yes.
And where do your other son and your 4 daughters live?
My first son is in Mexico. And my other 2 daughters are here. And the 2 daughters in Mexico.
2 daughters in Mexico and 2 daughters here. Do the 2 daughters that are living here live with you?
No.
Okay, so
They're married.
they're married. Okay, so who lives with you?
So I live alone.
Okay, so if
I left my house.
okay, so if your son Jesus is granted bond, he'll come live with you, is that correct? Okay.
Yes, sir.
Okay. You said you had 17 grandchildren as well? Congratulations.
Yes.
Um,
Thank you.
Do you know how many of those are granddaughters and grandsons? That's probably the last one. I'll take that. What are the general age ranges of your grandchildren?
La mayor tiene 28, es doctora en Monterrey. El segundo es hombre, tiene 20.
That's we don't have to do one at a time. What's your oldest one and what's your youngest?
Sí, tiene 28 y la más chiquita tiene va a cumplir 8 en diciembre.
My oldest granddaughter is 28. She's a doctor in Monterrey. My youngest granddaughter out of all of them, she's 8. He's gonna be 8 in December.
Now, of those 17, you have more granddaughters or grands?
I have 3 great granddaughters.
Okay, so 3 granddaughters and then the other 14 are grandsons. Is that right?
3 great
Oh,
granddaughters.
great-granddaughters. Oh, okay. Well, congratulations. Okay. Now you said that if he was granted bond, you would pay half of that amount, is that correct?
Yes.
But who would pay the other?
That's what I'm going to pay.
Right, you pay one half, but who pays the other?
How much would be the total? Because I thought from the 12th I would pay half.
Right, okay, all right, so we'll find out who's gonna pay the other, correct? All right, now, if your son comes to live with you or any of your daughters, your great granddaughters, granddaughters, when they come visit?
Yes, yes.
Are you aware of the nature of the charge that's currently pending against their case?
Yes.
Knowing that he is charged with that, do you have any concerns for the daughter, your granddaughters, and your great granddaughters?
No. No.
Okay, have you ever been concerned about that type of behavior upon Jesus?
No. No. Never.
To your knowledge, does Jesus drink alcohol?
Yes.
To your knowledge, have you ever had a concern for him abusing life?
No. No.
So he wasn't directed at any.
No. No. Only one. Only one beer.
Can we drink one beer at a time?
And one time.
One. So he's been drunk one time before, I'm trying to confuse.
No. No, I'm drunk.
Okay, all right, I think it's easy. Do you have alcohol in your home?
No. No.
Jesus comes to live with you, are you gonna allow him to drink in your home?
No. No, no.
Okay. Is Jesus by any chance in a relationship with anybody?
I don't understand.
Does he have a girlfriend? He's married.
He has a wife.
He has a wife.
He's
Okay.
married.
And where is she?
Today, hoy, trabajo. She worked today.
Where does she live?
Okie dokie, we're a couple of minutes in the Wayback Machine here, so let me nudge her past that little pause right there. There we go. Back on track.
Yes, he has 2 daughters.
What are her daughter pages, please?
The oldest is 12. And the other one is 7.
All right, any other questions?
I'll keep it brief.
No, no.
Do you have any concern that Jesus will do anything harmful to any of these grandkids, great kids, children that we talked about?
No. 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 No doubts.
And Jesus will be with you, so pending trial, he'll be living in life. That's all.
Yes.
All right, I have a couple of questions. It may just turn out to be one. All right, any objections? Do you have any minor grandchildren who actually spend the night at your home?
No.
No.
So if he were released on bond, one of the conditions most likely will be that he is not allowed to have any contact with minor children. Do you understand?
Yes, ma'am.
All right, I have no further questions.
That's all I have.
All right, thank you. Thank you so much for coming down and for dressing appropriately for court. Thank you. Oh, and excuse me to the interpreter.
Yes, ma'am.
I don't know if she's still going to need you to know what happens.
Okay, I'll see you.
All right, thank you. All right, any other witnesses?
No, Judge, that's all I have.
All right, state, any witnesses?
Not from the state.
All right, the court will hear argument unless there's any evidence from the state.
The only evidence without just entering the report is 6 Exhibit 1.
Any objections?
No, Judge.
All right, state exhibit number 1 is admitted without objections for purposes of this hearing. Have you had a chance to review state's exhibit number 1?
Yes, I have. Judge.
All right. What is there any relationship alleged, any alleged relationship between the defendant and the complainant?
I don't think they're related.
And the reason why I say that, because I'm reading state's exhibit number 1, and state's exhibit number 1, it was mentioned that there's an allegation of a criminal trespass at that location, but then the person is stating that they never signed a request that he not be allowed on the property. So that's why I'm trying to figure out what is the alleged relationship.
Well, they do know each other, Judge, but as far as a relationship, there really isn't one.
All right, so if you'll give that to the court reporter, please. All right, the court will hear argument. Defense, what are you asking for?
Judge, as you know, it's, the offense is sexual assault. It's not aggravated sexual assault. There are, you read the report, there's no independent witnesses who said they saw something, they heard something, they know something.
All right, so here's what I'm telling everyone, because I want the record to be clear. I have not received any testimony. My role here today is just to decide bond, not decide whether it's true or not.
Other than what you've read, what exists. Okay, I'll leave it at that. Mr. Murdoch has been in jail since April 1, so it's over 6 months. The bond, I think, is high at
So what are you requesting for a bond about?
30,000, Your Honor.
All right, defense is requesting 30,000 for a bond. What are you requesting?
Request of the bond state the amount that it is. We feel that it's appropriate for the charge. The facts has alleged up to this point, and the defendant's criminal history. He does have a TWI on his record card as well as a felony indecent assault here in Bear County. So it seems like this behavior is.
What do you mean a pending indecent assault?
I need to, I'm sorry, my laptop, it doesn't show a, conclusion, like, for a TWI can proceed, deferred education.
No, I'm back to the indecency. What is that?
I'm not aware of that.
Oh, no, I'm sorry, that's the issue.
All right, so all, you're telling me all he has is DWI?
On his record.
All right. If there's nothing else, this is what the court is going to do. There was no evidence presented to the court on what he's able to pay, what is in his bank account.
His mom, Judge, that's all he's got.
Well, I mean, no evidence has been presented to the court what his bank account is and how much money he has. This is what the court is going to do. The court is going to set his bond at $70,000. There's going to be partial GPS for employment only. Waive GPS fees. All right, is there anything else?
Says that you are no contact with the victim and minor children.
All right, there's to be no contact with the complainant, and there's to be no contact. Well, is the complainant a minor?
No, Judge. Complaint is not a minor. No, Judge.
All right, there's to be no contact with the complainant and no unsupervised contact with minors. All right, so he is due back here on, I think, the 20th for the state to tender an offer. State, are you able to tender an offer today? All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date. All right, we'll be back on November 20th. At that time, you need to let the court know whether or not you reached an agreement with the state. If you have not reached an agreement, then your next setting will be a jury trial date, and that will be sometime in the new year. All right, thank you.
Thank you. Recognize his
70,000, not a small amount. This is one of those cases that we probably could have discussed when we had our bail conversations on Sidebar, which, by the way, you should check out if you haven't seen Sidebar before. Tuesdays and Thursday evenings, 8 p.m. Eastern, 5 p.m. Pacific. It is me, but it is also a bunch of our channel members, so give it a look sometime. We'll stay in Texas, but we'll go over to Jefferson County, back to Judge Stevens.
Okay, so the other two cases in numerical sequence, 24 CR 351 and 24 CR 1613 are yes, both called the State of Texas versus Aaron Hill. You have Mr. Hill.
Yes, sir.
Present. With Mr. Turk, your attorney and the state's attorney does the defendant. We formal readings of the indictments and arraignments here. Can we proceed in summary?
Yes, sir.
In summary, sir, 351, we'll take that up numerically. In summary, that alleges that on or about January 29th, 2024, in Jefferson County, Texas, you committed a third-degree felony of injury to a disabled individual. Do you understand what you were charged with here?
Yes.
If convicted, you face no less than 2, no more than 10 years confined and in prison, and a fine up to $10,000 can be assessed. Do you understand? Agreement's been reached that you would be pleading guilty, found guilty, sentenced to 6 years in prison to run concurrently with other cases. Is that your understanding?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
So,
How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
guilty.
Sir?
Guilty.
That's yes. You have to respond to me. That's yes.
Yes.
Okay. gonna hold that one in abeyance. We're gonna go to the next case and come back to this one in just a moment. All right, in 1613, in summary, this indictment alleges that on or about July 16th, 2024 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with the use of a deadly weapon, namely a firearm. Do you understand what you're charged with here?
Yes.
A second-degree felony carries with it, if convicted, a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case here where you would be pleading guilty, sentenced to 6 years in prison to run concurrent with other cases. Is that your understanding of the agreement? I have to have an answer today.
Do you understand that? Yes.
If I follow this agreement, you have no right of appeal of your case. You understand? How do you plead to this charge? Guilty or not guilty? How do you plead to this charge? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 for each of these cases. If you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true and correct. State's Exhibit 1 tendered into evidence in each of these cases.
No objection.
Without objection admitted. Among other things, State's Exhibit 1 state similarly that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. So help you God in each case. Is that so?
Yeah.
State's Exhibit 1 made a part of the record for all purposes in each case. Pre-sentence reports waived.
Yes, Judge.
I will follow these agreements. If nothing further to add by anyone, I will make the findings that Mr. Hill, in each of these cases, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in each case. I so find you guilty in each of these cases beyond a reasonable doubt. I am following these agreements in 24 CR 351. You are yes. So and you are hereby found guilty beyond a reasonable doubt of this third-degree felony of injury to a disabled individual. And following the agreement, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. Do you understand what has happened in that case?
Yeah.
In 1613, this court finds you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. And these two sentences shall run concurrently with other cases. There will be an affirmative finding in this case in the judgment that a deadly weapon, namely a firearm, was used in the commission of this offense. Do you understand what has happened today, sir?
Yeah, no problem.
Anything else?
No, Judge.
Okay, we are in recess on these. There's one other matter, a dismissal.
Yes, Your Honor,
is
that
going
was
to be
the
filed.
AGL felony, the theft of a firearm, 1898.
That case will be dismissed. 24 CR 1898. That case is hereby dismissed. Two, Pam,
Yes, Judge.
you ready on that?
Yes, Judge.
That's all the problem with them.
Gotcha. Yeah, that. Yeah, those files.
You have, Judge.
I
From the trial document.
Back in the middle.
While you're flipping through there, you've got another plea coming on Prud'homme. Just trying to help, Judge.
Two, Pam.
Yes, sir.
Yes, sir.
Am I pronouncing that correctly? Okay.
And he'll have to come swear and fingerprint for me. Place your right hand, you swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Sorry.
Push it far there. And get one more time. Push it far right here.
All right. We call this case 23 CR 2102, the state of Texas versus Tu Pong Pham, present with her attorney, Mr. Kelly, and the state's attorney does. The defendant waive a formal reading of the indictment and arraignment here. Can we proceed to settle?
Yes, we do. And
In summary, this indictment alleges that on or about October 23rd, 2023, in Jefferson County, Texas, you committed the third-degree felony of assault, family violence with by impeding breath or circulation, by choking is what we refer to that normally. Do you understand what you're charged with in the indictment?
Yes, sir.
An agreement's been reached where you would be pleading guilty to the lesser included offense of assault. Is it FV? Is that family violence?
Family violence.
Okay. And in the indictment, it does state that you allegedly, intentionally, knowingly, or recklessly caused bodily injury to Alona Pam, a member of your family, household, or person with whom you had a dating relationship.
That shouldn't read dating relationship.
I understand.
I need
I'm
to-
taking, well, it doesn't apply, so it's not
Okay.
it's not relevant.
Yes, sir.
But the lesser included of intentionally, knowingly, recklessly causing bodily injury to a person who is a member of your family or household, that is a Class A misdemeanor, which means you face up to 1 year in the county jail and or a fine not to exceed $4,000. Do you understand the punishment range for this lesser included offense of assault, family violence? That's a yes or no?
Yes.
Okay. An agreement's been reached. You would be pleading guilty, placed on deferred or unadjudicated probation.
Yes, sir.
Is that, is everybody wanting 1 year? Is that what we want?
That's correct, Judge.
No fine or anything
No
like
fine.
that? Nothing? No other condition of probation?
She's going to have to complete the batter's intervention program.
Okay. Is that
is
the understanding?
More customary terms.
That would be part of the condition of probation. But is that your understanding of the plan?
Yes, sir.
Ma'am,
Yes, sir.
if I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor of assault, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
I've got on the face of the indictment here. On this date, defendant pleads guilty to lesser included Class A misdemeanor of assault, family violence. Any objection to that? All right, I'm going to follow this agreement and then you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. In State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, but the court is going to defer any finding of guilt, place you on deferred or unadjudicated probation for this lesser included Class A misdemeanor of assault, family violence for 1 year. There will be terms and conditions of probation, which are normal and customary for this type of offense. And among other things, you shall be required to complete batterer's intervention program as directed. And there are other terms and conditions which are normal and customary for this. You do well, it will be dismissed. You fail, your probation could be revoked. You could then be found guilty of this lesser included Class A misdemeanor of assault and punished up to 1 year in the county jail. So you're going to do well?
Yes, sir.
Good, good. The person that was the victim, who is this?
It's your daughter.
Okay. What's the relationship? Good or strange?
Not really existed since the indictment.
Okay. What are we doing about that? Does everybody want a relationship?
They were honoring the conditions of not having contact, Judge.
I understand. I want to know. What do y'all want to do? I don't, do we want the family unit back or not? Okay. I want to work with that. Tell me what needs to be done. I mean, you made a mistake. Welcome. The whole world makes mistakes. Everybody makes a mistake. Fix it responsibly. And that's blood relation. I mean, your daughter. Well, I've got two. And they're certainly precious. And I'm sure you think that way, unless you're an odd person, but I don't think you are. But fix this. But you know what love is all about and how it is carried out in a relationship. But assaultive behavior is not part of the way a family should be, and fix it. Can you? Good. Yeah. Anything else?
No, Jay.
Oh, that is all.
There we go. Ellie pulled out my my mic cable. I tried to talk to you and I couldn't, but here I am now. All right, let's go to Ohio. We'll go to the fancy courtroom. Judge Vincent Collada. Let's see what's going on there.
We're here today in State of Ohio versus Jacob T. Brown, case number 25-CR001360. Defendant is present in open court today with his counsel, Chad Mulkey. Your Honor, we're here today on a 2-count information that was filed on September 24th of 2025. Those 2 counts being pandering, sexually oriented matter involving a minor or impaired person, both felonies of the 4th degree. They do not merge. It's the state's understanding today that the defendant will waive his right to indictment, that he would plead guilty to both counts in the information. The state would then recommend a pre-sentence report and a psychological evaluation. There's no sentencing agreement, and that's the state's understanding at this time.
Thank you.
Thank you.
Mr. Mulkey, does that sound accurate?
That's all accurate, Your Honor. Also, my understanding is we would need to set a bond in this manner too, so when appropriate, we'd like to be able to go over that issue as well. Thank you.
Is this like a secret information in a sense?
It is, Your Honor. So there's an extra document for the booking as
To
well.
get him sent over?
I'm sorry, what was that?
There's an extra document.
Yes, the extra document is so that the jail knows to book him in.
Yeah, but where is it?
It should be.
Oh, there it is. I didn't see it at the bottom. Yep. All right, Mr. Brown, were you able to hear what the prosecutor and your lawyer had to say regarding, excuse me, what they believe your intentions are here today?
Yes.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'll explain in a moment what that means here in more detail. You're then going to go ahead and plead guilty to 2 charges that are set forth in the information, which I will also review with you to make sure you understand those. We will then continue the sentencing to a future day to get some evaluations completed, come back on a future date where there's no agreement between the parties at this time regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. You need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on here, all right?
All right.
All right. Let's get started then. How old are you, sir?
20.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
Nope.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charges you're accused of committing and what you're going to be pleading guilty to?
Yes.
You had a chance to look that over?
Yes.
Now, in that information, you are charged with 2 offenses, and what's alleged here and what you'll be admitting to is in count 1, on or between February 1st, 2024 and March 31st of 2024 in Lake County, Ohio, that you did, with knowledge of the character of the material performance involved, knowingly solicit, receive, purchase, exchange, possess, or control material that shows a minor or an impaired person participating or engaging in sexual activity, masturbation, or bestiality. That conduct constitutes the offense of pandering, sexually oriented matter involving a minor or impaired person. It's a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes.
Any questions for me about that?
No.
Count 2 alleges the same offense, only that it occurred in a different, between a different time frame. It's alleged in this count on or between April 1st, 2024 and July 16th, 2024, again in Lake County, Ohio, that you did with knowledge of the character of the material or performance involved, knowingly solicit, receive, purchase, exchange, possess, or control material that shows a minor or an impaired person participating or engaging in sexual activity, masturbation, or bestiality. That conduct constitutes the offense, again, of pandering, sexually oriented matter involving a minor or an impaired person. It's a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 2?
Yes.
Any questions for me about that?
No.
So you understand the nature of the 2 charges that you're pleading guilty to?
Yes.
Well, then before I can accept your guilty plea to either of these charges, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have the right to have this case presented to a grand jury. So the charge I just read to, we call it an information. An information is actually criminal charges that are brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. And what a grand jury is, it's made up of a group of citizens that are here from Lake County that get together and they meet privately in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Now, everybody here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in any way in making that decision. And you have that right as well.
Yes.
But you can give up that right if you want and go forward on the charges brought by the prosecutor and the information. Your attorney has indicated he believes that's what you want to do. Is that correct?
Yes.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in my possession here at this time, somewhere up here, here it is, a document called a waiver of indictment, which sets forth everything I've just explained to you about this grand jury process, and they want to give up that right. Before I can go any further, I need to be assured you understand this document and that you sign it here in open court. Now, my understanding is before I walked out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes.
Mr. Mulkey, is that accurate? Did you read this over with Mr. Brown, review it with him, answer his questions?
Yes, Your Honor, I did.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Brown?
Yes.
So you understand what that document says?
Yes.
Do you have any questions for me about it?
No.
Now, it also appears that you signed the document. Did you, in fact, sign it?
Yes.
Mr. Mulkey, you witnessed that?
I did, Your Honor.
Ms. Kutz, you as well?
Yes, Your Honor.
All right, so I'll make that document part of the record. At this point, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you, first of all, have the right to have a trial in this case. Now, a trial could be to me as a judge, or I listen to all the evidence, and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors, 12 jurors, would have to be a unanimous decision, which means all 12 of those jurors would have to agree together, one way or the other, as to each count whether you're guilty or not guilty. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes.
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what it actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of the charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal charge we're dealing with, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of the charges beyond any reasonable doubt before you could ever be found guilty at a trial of the charges. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least to try to do that if we had a trial, the prosecutor would call witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. That order is called a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if that person wasn't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that is your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we went to trial and you were found guilty of either of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all for me then regarding these rights we've just discussed? These are all the rights you have and all the rights that you are giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts that are being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand?
Yes.
Understand that. Now, as far as sentencing goes, you're pleading guilty to 2 felonies of the 4th degree. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Now, since these 2 counts don't merge, meaning there's 2 separate incidents and they occurred at different times or 2 separate acts, if I were to send you to prison or impose a prison sentence, I would impose a prison term on each count. Then as the judge, I have the discretion to run those sentences either concurrent or consecutive to each other. Concurrent means together. You serve them at the same time. Consecutive means one after the other. You serve the prison term on the first count, complete that, then serve the prison term on the next count. So you understand the difference there?
Yes.
So in this particular case, if I impose the maximum sentence on each count and ran them consecutive to each other, you're looking at a maximum possible prison term, in this case of 3 years in prison that could be imposed at sentencing. You understand that?
Yes.
And that can also be consecutive to any other prison sentence you may be serving for some other case, if there is, or that you're being sentenced to if there's some new case that would occur. You understand that?
Yes.
Now, do you have any other pending charges against you anywhere else?
No.
Are you on, or were you on probation or community control, parole to any other courts or agencies when any of this happened?
No.
If a prison sentence is ever imposed in this matter, upon your release from prison, you would be placed on what is called post-release control. We sometimes call that parole. That's a period of supervision you would be on after you completed whatever the prison sentence was. And in this case, it would be mandatory for 5 years. Do you understand that?
Yes.
And while you were on post-release control, if you ever were, and you violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence, there's other sanctions and penalties that can be imposed. You could be fined up to $5,000 on each count, so a maximum fine of $10,000. You could be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable as well. Do you understand all that?
Yes.
Further, as a result of pleading guilty to the offense we're involved here is what we call a sexually oriented offense. And because of that, at the time of sentencing, you will be classified as a sexually oriented offender, and you will be required to register the address that you live at, as well as where you work and or go to school, if that's applicable, with the sheriff of that particular county. You'll be required to do that immediately after you get out of any incarceration, if there is incarceration, and then every 180 days thereafter, and you'll have to do that for 25 years. Do you understand that?
Yes.
And I'll advise you more specifically of all the specific requirements at the time of sentencing, which is when I'm required to do that, but I need to make sure you understand that that's going to be a consequence of this plea of guilty. Do you understand that?
Yes.
And just for the record, that's referred to as a Tier 2 offender. Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison's not mandatory or required with either of these charges. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're going to be asking for. I'll look at all the information presented, then I'll make the decision I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on community control, it could be for up to 5 years of supervision, and as the judge, I had the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail as a condition of probation. Do you understand that?
Yes.
Further, if you are on probation, you ever violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could order more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I sent you to prison, again, it could be 6 to 18 months on each count. I could run those consecutive, so possibly 3 years in prison, and that also could be consecutive to any other prison sentence you may be serving at that time for some other case, or that you're being sentenced to at that time for some other case. Do you understand that?
Yes.
Lastly, when we do proceed to the sentencing hearing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend a sentence to the court. The prosecutor also has a right to recommend a sentence to the court. Do you understand that?
Yes.
Do you understand that whatever any attorney says at sentencing regarding what they think the sentence should be, it is just that, what I said, it's a recommendation. I don't have to follow that if I didn't think that was what was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all regarding these possible penalties that you face by pleading guilty?
No.
You understand all the possible consequences we just discussed?
Yes.
You still want to plead guilty?
Yes.
Have you had enough time to talk about the case with your attorney and have him go over everything with you and answer your questions?
Yes.
Are you satisfied with his advice and counsel?
Yes.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to?
I'm sorry, what was that?
Any questions about anything we just talked about?
No.
Do you need any more time to talk to your lawyer before we go forward with your actual plea of guilty?
No.
All right, then what's going to happen at this point, the prosecutor is going to explain for me what she believes the evidence would be at a trial if we had to have a trial. I want you to listen to her, because then I'll have some questions for you about that, all right?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond reasonable doubt that on July 8th of 2024, Mentor Police Department, specifically Detective David Paltrow, was assigned a cyber tip, which included 4 video files uploaded to Google Photos under a specific Gmail account, austin.maslin1@gmail.com. There were 4 videos uploaded in February and March of 2024. Those videos included anal penetration of a toddler and masturbation of prepubescent females. Officer began investigation. The Google account, the number that was attached to that Google account came back to Verizon Wireless to a Jacob Brown of Lakeshore Boulevard in Mentor Lake County, Ohio. The detective checked the Mentor Police Department records and found a Jacob T. Brown at that address. The date of birth of August 13th of 2005, the current address showing on Dunbar Court in Mentor Lake County, Ohio. A search warrant was obtained for Google records. The Google records were provided on July 16th of 2024. The Google Pay information showed the account belonged to Jacob T. Brown, the defendant, at Dunbar Court address. There were several credit cards in the defendant's name listed as well. There are also 3 emails sent to that austin.maslin1 email address from the defendant's Mentor Schools email address, one including a link to a mega folder. That link had been deactivated due to gross violations of the terms of service. Mentor Police Department officer detective was aware that mega is commonly used for child sexual abuse materials and child sexual exploitation materials. Reviewing further through the Google documents, there was a web history of 3 mega folders. 2 required decryption keys, but 1 was active and had been accessed as recently as April of 2024. Contained approximately 431 files, mainly video files. At least 85 of them were prepubescent children involved in various sexual behaviors from the ages of infant up. Some of those activities included fellatio, masturbation, cunnilingus, and various types of penetration. Through a Facebook account, detective determined that the defendant had moved to Pennsylvania for schooling. Mentor Police Department made contact with a detective in Pennsylvania who went and spoke with the defendant, who admitted creating the austin.maslin1 email account. He indicated that he had used a Walmart phone he purchased. He had purchased it because his mother had restrictions on his main cell phone, but that phone had since been destroyed and he no longer had it. All of these images connected to Lake County, Ohio, and that would have been the state's evidence.
Mr. Brown, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we did have a trial?
Yes.
What, if anything, did they say about those facts as she presented them? Are they true? Did you do what she said?
Yes.
Very well, and regarding counts 1 and 2 of this indictment, each charging you with the offense of pandering sexually oriented matter involving a minor or an impaired person, each felonies of the 4th degree. What is your plea to each of those 2 counts?
Guilty.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just discussed with you. Before I can accept your plea, I need to make sure you understand what this document says and that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes.
Mr. Mulkey, is that accurate? Did you review this with your client, answer his questions, explain everything to him?
I did, Your Honor.
And did he indicate an understanding of it to you when you did that?
Yes, he did.
Is that correct, sir?
Yes.
You have any questions for me about what the document says?
No.
You understand it?
Yes.
Now, I've also seen that it appears that you've signed this document. Did you in fact sign it?
Yes.
Mr. Mulkey, you witnessed that?
I did, Your Honor.
And Ms. Cut, you as well?
Yes, Your Honor.
Very well, then at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of counts 1 and 2, each charging the offense of pandering, sexually oriented matter involving a minor or impaired person, each felonies of the 4th degree, and each in violation of 2907.322A5. The court will defer sentencing or order a pre-sentence report and investigation along with a psychological evaluation. As to bond, Mr. Mulkey?
Thank you so much, Your Honor. May it please the court, counsel, and others here today. Your Honor, my client has been in constant contact with my office. He's taken an active interest in the case, as myself with the prosecutor regarding our negotiations to bring this to an information hearing from a standpoint of a secret versus a preliminary hearing. So all that to say, Your Honor, is that he will appear for court. He does want to resolve this matter. I explained to him that if the court does grant him a recognizance bond and he fails to appear, assuming the state would prove that the bond was in effect, that he would be facing a new felony charge for failure to appear, so he fully understood that. We are asking the court, he is asking the court for a recognizance bond since he did appear here of his own accord today. He does have a valid driver's license. He's the primary driver of a vehicle. He can transport himself easily to and from court, probation hearings, and so forth. He's 20 years old. He's gainfully employed. To my knowledge, he has no current record, Your Honor, and no past record either. So for those reasons, Your Honor, we would ask the court to carefully consider recognizance bond in the matter. He is indigent. He has no money to post a cash surety or even a 10% bond at this time. So he's made good faith efforts to resolve this matter and has appeared here today, knowing what he's looking at, Your Honor. Thank you.
Thank you. What's the state's position on that?
Your Honor, we don't oppose an recognizance bond. We'll clarify that there is a juvenile record for the defendant, which the court will be made aware of at the time of sentencing. We would ask for conditions to be put on that bond or any bond that the court chooses to give. We would ask for no unsupervised contact with minors and no use of the internet, or at least no use of social media, with probation having access to any electronic devices.
Well, that's the standard conditions that we use. So I'll impose a bond of set your bond of own recognizance with the condition that the defendant have no unsupervised contact with minors, and I won't say no internet use, but no use of social media, and you should provide probation the ability to monitor or check your sites if they desire that they want to do that. You understand that?
Yes. I have a question, Your Honor. Your Honor, my client has indicated by way of employment, he's a DoorDash driver due to the nature of that employment. I could foresee a situation where he's potentially bringing food to a residence or other location where there could be minors present for the limited purpose of dropping off the food on the front doorstep. I just want to make the court aware.
No, that'll be permissible.
Thank you, Your Honor, for the clarification.
So what this means then, Mr. Brown, is a bond owner recognizance. Your attorney alluded to it, but I'll explain it. It means you don't have to put up any money. You have to sign paperwork, which I believe you did already. So your signature is your bond, but if you fail to appear for any court hearings while you're released on an owner recognizance bond, that's a separate felony, which is the same level of what you just pled guilty to, actually. That you can go to prison for an additional 18 months on if found guilty of that. So it's obviously important you show up at all future court dates. And Mr. Shadow, when's the sentencing date in this case?
12/1 at 1:15, sir.
So September 1st at 1:15 will be your next court date. So that's what you need to make sure you're here for. What did I say?
September.
Sorry, December 1st at what time? 1:15?
1:15, yes, sir.
Is your next court date, and that's what you need to make sure you're here for, all right?
Okay.
Now, prior to that, you need to make sure you go to the probation department when you're supposed to. Now, if you fail to do that, and that's not a felony you can be prosecuted for, but If you don't do that, they're not gonna be able to do a pre-sentence report. And if I don't have a pre-sentence report, I can't even consider probation as an option, so prison sentence will be imposed if that were to happen. The purpose of these reports is so I can learn more about you before sentencing. Probation department will conduct interviews with you. It's important that when you meet and speak with the folks over there that you are open and honest with whatever you're discussing, because they're gonna check and verify whatever you tell them. And if they learn you're misleading them in any way, they'll let me know that, and I would obviously consider that at sentencing. You understand that?
Yes.
Further, one of the conditions of your bond also, I set forth a couple others just a moment ago. You have any questions about those?
No.
You also can't use any drugs. They may request that you provide urine samples. If they do, you have to provide that sample, and if it comes back positive for any substance, including marijuana, then your bond would be revoked and a warrant would be issued for your arrest. Do you understand that?
Yes.
All right, so you're going to leave here now. You're going to go to the probation department, meet with them, fill out some initial paperwork, and get your dates to come back. So make sure you do that when you leave here, all right?
Okay.
All right, is there anything else for the record, Ms. Cuss?
Just that the defendant also has to go
Oh,
to
yeah,
jail to
that's
be
right.
looked at.
Another paper, we're going to send it over with you, a copy of it. This is the first time that you've been, never arrested or anything on this charge. You're going to need to go in, when you go to the jail, you'll need to get booked in. And you'll get booked in and out. But you need to make sure you do that. So you can do that first thing before you go to the probation. Or after, whichever works out, whatever easiest there. But make sure you do both of those, probation department and then the sheriff's department. I go to the sheriff's department first and take care of that, then go upstairs, because then you can just sleep when that's over with. But you'll get that too. So Stan, make sure you give him this copy of that to take over with him. All right, then anything else? Is that it then?
Yes.
All right, thank you both.
All right, so Wahoo just put in the chat, this is a bad sentence in my humble opinion. This wasn't a sentence yet. It was an acceptance of a plea. But it definitely looks like it's going to be a bad sentence. I kind of cringed when he talked about probation being an option. You know, I've been on record how much it bothers me when young people throw away their lives. This is somebody who's 20 years old. In the same respect, I don't know what redemption there is for something like this. It just, time and time again, they re-offend and they re-offend and they re-offend and they re-offend. He'll get out and odds are he'll do it again. There doesn't seem to be a fix for this problem, unfortunately, other than stop making people who make these kind of mistakes and choices and everything else, but what do I know? Okay, let's go to Judge Boyd. We'll go back to Texas.
All right, the court is calling 2025 CR 001800A and 2025 CR 001802B, State versus Alex Avila. Can I have parties announced?
Megan Galloway for the state. Faith Castillo for defense. Your Honor.
And we have an interpreter. Again, if you could raise your hand for the record. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Thank you, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Good morning, Your Honor. My name is Catalina Delgado, license number 2222.
And are you Alex Avila?
Yes.
And counsel, have you been able to communicate with your client?
Yes, Your Honor.
All right, we're here for a sentencing. Have both parties received the PSI and TAP evaluation?
Yes, Your Honor.
Any objections to the PSI or TAP evaluation from either side?
No, Your Honor, just some clarification points on the PSI. So, on the previous, it says previous criminal history. We're coming together on all of the cases, so that's just to note there was no actual prior to these instances that were taking place.
All right. Are there any witnesses?
Yes, Your Honor, we have one, Marisol Morales, if we could call her to the stand.
All right, if you'll call your witness in.
Defense would like to call Marisol Morales.
All right, if you'll remember to keep your voice up so that the court reporter can hear.
Yes.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Marisol Morales.
All right, you may proceed.
Good morning, Ms. Morales. Can you state your occupation for the court today? I am a licensed master social worker for the public defender's office.
And I'm so sorry, if you could not turn towards her when you speak, it's just so the court reporter can hear. Thank you.
Ms. Morales, how long have you been with the public defender's office? Approximately 8 years. And what do you do for the office? I meet with our felony clients to do assessment. Do you have any background in the work that you do, any licensures? Yes, I'm, like stated, I'm a licensed master social worker with a specialty in mental health and substance use. I'm a licensed drug and alcohol counselor. I have a certification as a trauma professional. I've completed approximately 3,000 hours of clinical supervision with mental health diagnosing and assessing. I've worked in the mental health and substance use field for approximately 27 years. And have you worked with clients around these type of charges before? I have. I've provided expert testimony in 17 felony cases. Has that been here with Bear County? Yes, ma'am. In other counties? No. Ms. Morales, is this a copy of your resume? Yes. Your Honor, I'm tendering a copy to the court and to prosecution defense exhibit A copy of Ms. Morales's CV.
Any objections to the court reviewing the CV? No. All right, then defense exhibit A will be admitted.
Your Honor, at this time, due to Ms. Morales's education, licensure, and over 27 years of experience in the fields of mental health, trauma, and substance use, we'd like to offer her as an expert in social work.
All right, any objection? No. All right, you may proceed.
Ms. Morales, are you familiar with the case today? I am. How did you get started with it? It was referred to me as the attorney for the case. Do you create any logs when you review information? I do. I prepare notes or take notes, yes, when I'm meeting with an individual. And so you're familiar with Mr. Alex Avila, correct? Very, yes. What did those meetings look like? We met over the course of the summer, approximately 3 months. I spent about 20 hours with him, interviewing, assessing his life history. Is that your normal routine with felony clients? Yes, with any client. And how long are these meetings? Anywhere from an hour to an hour and a half. Are they in person? Are they over video? It's a mixture of video and. So you completed an assessment for Mr. Avila? I did. How many times do you recall meeting with Mr. Avila? Probably about 10 times. And during those meetings, what do you talk about? We go over his background, childhood, education, family history, starting at the beginning, any trauma that the person may have experienced. Just an overall picture of who the person is. Okay. Do you remember preparing it for Mr. Avila? Yes. I'm showing a copy of the assessment to Ms. Morales, tendering a copy to the court.
Any objection?
And also to the state.
I would object just to it being admitted, and she can ask questions about like the work that she did, but as far as the
All right, the objection will be sustained.
Ms. Morales, you spoke with, Mr. Avila, correct? And what was his background that you?
Very, born and raised in Mexico, parents married, most of his education was from Mexico. Nothing stood out that he reported, any traumatic events as far as any physical, emotional, or sexual abuse. They arrived here in the United States when he was about 16 years old and enrolled in the San Antonio School District.
Did you review any mental health assessments with him?
Did I review any? No,
No, okay.
there were none available.
What about substance use?
We did review his substance use history and he did not meet the criteria for any diagnosis.
I'm gonna move on to different considerations you make when you're meeting with clients. What are the ones that you take into account?
Well, when I'm doing an overall assessment for somebody, it's not just looking at their whole life development, what's happened, how did we get here? But I also look at mental health, anything that may have impacted that, anything that may have impacted normal human development. I also conduct assessments for risk.
Are there different type of factors that you take into consideration?
For any risk assessment, like it's itself or anyone in the court system, we take a look at factors such as the criminal history, the age of the offense, whether any substance use or mental health were factors that played into how they got today. Their marital status, their education level, their work history, whether they show any disposition to criminal orientation, several factors.
And let's start with the first type, static factors. What do those?
The static factors are things that do not change in the person's life, which typically is the criminal history, the age of the offense, their whether their parents were married, there's things that are kind of black and white.
And what did you find from Mr. Avila?
This is his first criminal offense. That was a big factor that impacted his eventual risk level.
And how old was he at the time of the offense?
He was 17.
And does that have any effect on your evaluation?
Well, it's a big consideration when we're talking about risk and how we got here. That's the purpose of my assessment, is just to give context on what happened. And for Mr. Avila, he was 17 at the time of the offense. And as we know, particularly this court, that 17-year-olds don't exactly have always great decision making. At that age, their brains are still developing. Their prefrontal cortex, which is kind of where we have our decision making and our impulse control, is not fully developed. And that was one of the factors that I took a look at with Alex.
Does anyone else in his family have any history of criminality that you know of?
No. And I did speak with both parents, and there was no criminal history reported on minors.
What about early behavioral problems?
No, Alex actually was a pretty typical average adolescent. Up until this offense, he was basically going to school, very involved with soccer. There was nothing really outstanding happening in his life prior to something.
You mentioned you reviewed and spoke with him different school records. What did school look like for him based on what you talked about with him and what you reviewed?
Well, they got here when he was about 16. Usually when individuals arrive here when they're younger, it's very much easier to assimilate. They pick up language quicker. Their skilled, and they're a little bit more like sponges, but the little bit older that you get becomes a little more difficult. But in reviewing his records, he actually was an average student without BNC, no disciplinary or attendance issues.
What about the dynamic risk factors? What are those?
So the dynamic risk factors are things that can see in a person's life. That's where we look at mental health, substance use, their peers, their attitudes towards crime, those things that can fluctuate throughout a person's life course.
And what did you find from Mr. Avila?
Well, one of the things that I take a look at is the behavioral history. And because as we get older, there are individuals who can display pro-criminal attitudes, and that's not something that I found with Alex. And spending time with him and talking to his family, looking up at the school records, he doesn't seem to, he does not display antisocial personality traits at all. He generally thinks more of school, pretty and substance use, or mental health that was impacting.
I want to talk more about the impact of him as a young adult. What did you find when looking into the case in terms of the implication of incarceration?
Well, the time of the offense, Alex was 17. Now he is 18. And unfortunately, what the research tells us is that individuals who are in that young adult age group are at much higher risk of victimization in the prison system, especially for first-time offenders, that more at risk for physical and sexual assaults. There was a study 2013, I believe, by the Bureau of Justice Statistics that Texas is one of the highest reporters of violence against individuals between the ages of 18 and 20.
And so how does that involve Mr. Abu?
Well, it places him at high risk. Absolutely. He would be facing significant challenges due to his age, putting him at risk with older, more experienced individuals who are in the system, and that can lead to more issues that come up later on in his life.
In your overall expert opinion after meeting with Alex and conducting all of your research, how would you describe to the court Alex overall?
I would place him probably lower end of being a risk to the community. That's one of the factors that I do take a look at. I understand the nature of the offense of the individual. I understand what has happened, but for Alex, he's got a lot of protective factors that help mitigate those risk factors that he may have. He does have a supportive family. He was going to school. He's single. He doesn't have any children. And I think that would place him at the lower end of being a future risk to the community.
Ms. Morales, did you have a chance to review the pre-sentence investigation report?
I did.
Was there anything you disagreed with within the report?
Maybe not necessarily disagree. I just have a very different perspective because I was able to spend a significant amount of time with Alex, and that would be, I think, the assessor for the PSI put a pre-contemplation contemplation stage, and that would mean that maybe he's not ready to accept what he's coming up against. I would probably place him in the preparation, which is he has expressed a lot of remorse for what has happened, he fully acknowledges and takes responsibility, and I think those are very important factors. And we're looking at whether somebody will return to committing crime.
Is there any difference if a youth takes accountability early on versus not taking any accountability at all?
No, like I said, it makes a huge difference. That's actually one of the factors that we also look at when assessing risk.
No further questions, Your Honor. We pass the witness.
All right, state.
You stated that you're familiar with Mr. Abijah, is that correct?
Correct.
Okay, you became familiar with him within 8 times in months of May and August. Is that fair to say? Yes. Okay. And so in your assessment of him, you stated it's your testimony that you place him on low risk. Is that correct?
Correct.
Okay. And so what metric are you using to determine whether he's a risk to the community?
It would be similar to what probation, their trust system uses, looking at the static and dynamic factors. And I did list some, looking at antisocial attitudes, antisocial fears, personality patterns, history of antisocial behavior, marital factors, in education, employment, pro-social, leisure activities, criminal history, age of offense, family history. It's similar to what probation uses.
Okay. And so regarding the criminal history aspect of it, you stated that this was his first criminal offense. Is that correct?
Yes.
Okay. And so when you're factoring in your assessment, you're aware that he's here for 3 separate aggravated robberies.
Correct.
Correct?
Correct.
Okay. And so when you're doing your assessment, you just count that as one criminal transaction, or do you factor it in as 3 separate offenses?
3.
Okay. And so it's still your belief that this involvement, 3 aggravated robberies, you believe that he's a low risk to community?
Yes, because I'm not just looking at the offenses. There are other factors that you have to look at in order to make a complete assessment of what their risk is. So although the criminal offenses are a factor, it's not the only thing that we have to take into account.
Okay. And so something else that you take into account is the support that he has surrounding him. Is that correct? And that's something that's been unchanged since before and after the offense, correct?
The individuals that are supporting him, no, that has not changed.
Okay, because his parents have been married, correct?
Correct.
He has siblings, correct?
Correct.
They all came to the United States together, correct?
Correct.
They were all living together at the time of this offense, correct?
Correct.
And so how do you factor that into what's going to change between before, when he had this support system and chose to commit the crimes, and then now?
Well, one of the things that did change in their family makeup was that when they were living in Mexico, mom was a stay-at-home mom and father was the main provider for the household. And that changed when they came to the United States, where both parents had to work. And when we talk about support, it's love and encouragement, but the way the house was running did significantly change from what Alex had been raised with up until the age of 16.
Okay, so it's your opinion that that factors into his choice to go commit 3 aggravated robberies?
Based on everything that I know, yes, that is a factor that I also consider.
Okay, and is the mother still currently working?
I do not believe so.
Okay, yeah, but either way, I mean, based on your report, one of Alex's siblings has health issues, is that correct?
Correct.
Okay, and so mother and possibly father got at work, they're pretty busy taking the sibling to different doctor's appointments, correct?
Correct.
Okay, and so there's a lot of time periods possibly that if this court were to grant him probation, that he would be alone and possibly falling back to the wrong crowd, correct?
My understanding and in speaking with the family, that dynamic is going to change. That's why it's a dynamic factor. It's things that can fluctuate up and down. And the family has renewed a commitment to do things differently and sort of evaluate the importance of certain things in their life. And one of the things that they have chosen to do as parents is to become more involved and make the necessary changes to provide a supportive environment for Alex.
Okay, but there's still possibility, right, that he would be by himself while the mother's taking the other child to health appointments, correct?
Yes.
Okay. And you stated that there's significant challenges in prison. Okay, one could say that there's also significant challenges in the Bexar County Jail, correct?
Correct.
Okay, but Mr. Oculus seemed to get along fine at the Bexar County Jail, right?
There have he has been the victim of some physical assaults in the jail.
Have they been reported?
No, and that's really not unusual. If you're telling jail, bad things can happen to you.
But he's made some friends in jail, right? Even an inmate got just to write a letter on his behalf, correct?
Yes, he has found some peers in the jail.
We possibly.
Just a few clarification and follow-up questions. Ms. Morales, when you're conducting your evaluations and assessments, family is one part of it or all of it?
No, it's one part.
Okay. And so when you're sitting down with parents and you're talking with Alex, what are the type of things that you talk about, and what changes do you see?
Well, we discuss the current situation, what their thoughts and feelings are, what they would do different. That's always kind of a difficult topic to talk to parents about. Obviously, no parent wants this for their child. But Alex's parents have done some thinking, evaluating what did they do, what could they have done differently. And I think that based on my conversations with them, that it's kind of, it's been their come to Jesus moment, if I may say, realizing that some mistakes were made and the things that they want to do differently.
I know the state asked you a couple of questions about Alex being by himself. Are there any significant risks in any of your assessments when it comes to him maybe being at home with his siblings by himself?
As far as, I'm sorry.
As far as how behaviors or patterns or anything like that when you review the assessments?
Well, obviously, no one is going to be under 24-hour surveillance in their home. So yes, there will be moments that Alex will be by himself or alone with his siblings. And that's where the importance of level of supervision, the engagement with his probation officer or whoever the supervising person is, that's going to be very important. Also, going back to school, doing that full time. He didn't have any disciplinary when he was attending school. And he has really verbalized his understanding of the importance of education if he's to turn things around.
So being on probation would actually help Alex in this instance?
For Alex, yes. There are classes that he would be required to take, reporting requirements, obviously probably UAs that he would have to take. He would be on a more rigid schedule and also being more around, his parents have committed to being more responsive to any issues that they may see.
Further questions, Your Honor?
Any further questions?
No, Your Honor.
Defense rests.
I just have one question.
Yes.
Any objections? So are you aware that in the stipulations, it says that at the jail, he was using another inmate's PIN number to make phone calls? Elaborate.
So Alex is kind of caught in between the adult but not really adult stage of thinking.
Mhm.
So it's not unusual that peers, people his age, may have a bigger impact at this point. The good thing is that changing can think, that thinking can change. He can learn new skills, his brain, the prefrontal cortex and the amygdala will be making those connections as he gets older, which will lessen the impulsivity and give him more emotional regulation and making good decisions.
All right, thank you so much.
Maybe excuse me.
Yes. All right, do you have any further witnesses?
No, Your Honor, defense representative.
So I previously spoken with Ms. Castillo, and there are some letters that I'm not objecting to her offering.
You like a copy? Up.
Court will review letters that are typical. Just give me a couple of minutes. Okay, one is in Spanish.
We provided the
Translation.
the translations, Your Honor. We just kept the originals for records.
Read Spanish, but I don't want to mess up the interpretation.
We thought ahead.
All right, I appreciate that. Right, the court has reviewed the documents. Is there anything your client wishes to say?
No.
If you all can, I understand what the witness stated, but if y'all can explain to me how he commits one aggravated robbery, pulls a weapon on somebody. Then in the report, he says he's only doing it. And this is from the stipulations. He's saying he's only doing it because somebody forced him to do it, some man he doesn't know. And that he was at Sam Houston High School attending. But my understanding from testimony is that he was homeschooled. And I guess at some point he went to Sam Houston.
Yes, Your Honor. So he transitioned schools because he was finding himself in a position with these kids that he was trying to escape.
All right.
And so that was part of the reason why he transferred schools to a different location to try to get away from the environment that he was experiencing.
All right. So if somebody can explain to me how he commits one aggravated robbery, and then the next month he commits another and he doesn't internalize that this is the wrong thing to do.
I think the main thing, Your Honor, that was affecting Alex at this time was his environment and this external pressure, threats, and the people he was around at that time. And with him being so young and trying to understand exactly what is the right decision, how do
What
I?
were the other people who were with him?
They were around the same age, Your Honor. And it's those situations where, you know, you have a group of young kids, Alex, who wasn't the one, you know, holding the gun to the store clerk, but knows, you know, I'm in this tough position. I'm being threatened. At the same time, I know this is wrong. And I want to be clear, Alex from day one has taken accountability for everything.
Right, so if he's saying that he's being threatened, unless the law has changed, maybe it has, I don't, you know, say that I know everything, but if he's committing an offense under duress, then isn't that a defense?
It is, Your Honor. And we talk about these things with clients on how they wish to proceed. And
So he doesn't want a jury trial?
at this time, no, Your Honor.
Okay.
Mr. Avila has been through more than most people since his young life. And there are times when, as a kid, he's trying to make the good decisions with the influence of his parents, moving to a new country, trying to get the health care for his brother. And as we stated to the court, he takes accountability for everything, and he knows exactly where he went wrong. And I think one of the things that spoke the most to me was when I was sitting with Mr. Avila and we were talking about letters from people and family, and he's the one himself that said, I wanted to write something to judge. And we sat several times where we passed revisions. He's like, I want to make it as grammatically correct as possible. What else? What can I talk about? And that exchange really spoke to, I think, the core of who he was and who he is. He's recognized where things have gone wrong, and he's recognized where things can go even worse for him in his life. And I think that's a lesson that a lot of people who come before the court learn at different times. And so for me to see that growth in him at such a young age when speaking with him, I think is what spoke the most to both the social worker and myself. Mr. Avila is someone who was caught in the wrong place, wrong time, wrong factors. But he is also someone who takes accountability. He is also someone who is trying to carve out steps for himself and create a plan of success. And to see that for someone his age, I think is pretty remarkable. I told him the options, and we've discussed what could happen. And, you know, he's asking the court for probation, and he would like the chance to tell you and show you exactly what he is capable of and how he can turn his life around. And I wholeheartedly think that that chance should be extended to him. Let him prove to you, and if not, the alternative as well. But at least give him this chance to show you exactly what he has learned, what he wants to do, and how he wants to move forward with his life. Not only to correct the harm that he's caused, but also to become a productive member.
All right, state.
Regarding this offense and the letters that I reviewed during the time of his incarceration, yes, the defendant has come to learn that what he did was wrong, but I mean, he knew it back then. And in his letter that he wrote, he's falling on the sword because he knows that he's coming before this honorable court. I think that in reviewing the stipulations, I think that he's displaying a continued pattern of, you know, with the use of other people's SID numbers, that is against the rules that are in jail. So a pattern of continuing criminal behavior. And then also, I mean, this was not just one aggravated robbery. It was, they hit one store and then are, you know, collecting and appropriating property from that store. And then they go back. And these are people that he met at school, I might add, but, and then they go to another store and then a third store. And so while I understand what counsel is saying, I mean, this was a continued pattern of criminal behavior, violent criminal behavior, where he states that he was aware that these robberies were going to occur and still chose to engage in this criminal conduct, Your Honor.
All right. So here's the thing, and I want you to understand my thought pattern and why I'm doing what I'm doing. I talk to children all the time, and you know what I always tell them? If you're with a group of friends and you all are planning a robbery, you might as well go in the store yourself with a gun, because if somebody else went in the store with a gun, it's like you went in the store with a gun. That's the way Texas law operates. And my problem with you is I understand you're young, and that's what I'm trying to balance. I'm balancing the fact that you're young. I'm balancing the fact that you didn't have a gun. Because I've had clients before where they're just the lookout. Somebody gets killed, they're charged with murder, they're looking at life in prison. But you were more than just a lookout. You're opening doors for people. And part of the reason why everybody is charged the same is because historically, if you look at the way the law was written, they're thinking that maybe this crime would not have happened but for your participation. Sometimes if somebody says, well, I'll be the driver to this robbery. Well, maybe if that person would have said, no, I'm not driving anybody, then everybody would have said, well, we can't do this. We're not going to do it. But you continued, and it's not just one. So the state is asking for a cap of 10. I'm balancing your age. Hopefully you have learned something. And I'm also balancing the fact that you did not have a weapon. But at the same time, I'm balancing the fact that after everything happened, you all sat around and counted money. Do you even remember what happened to your share of the money, what you used it on?
None of us.
I didn't spend it.
Sometimes people go to a convenience store, they end up killing the clerk, and you know what? They end up with $20. Was that clerk's life worth more than $20? Most definitely. Is time going to prison worth more than the $20 you had? So I'm going to find you guilty. Does anybody want to speak to the cap?
We would ask for the lowest possible. We know that the court is taking into consideration everything that is happening. Just so Mr. Avila can get what he has planned, done, and he doesn't waste time in the beginning moving and potentially experiencing more negative things that would harm and actually impact him coming back to the system. We understand the court's position, and we understand the things the court's taking into consideration. And I think this is one of the opportunities where the law allows for just this, where you get to exercise your discretion.
But I am asking for the time. I did review everything that was prosecuted and over testimony with the witness, which was provided to me, and that was factored into the plea bargain. And I think another aggravating factor is that there were other people that were with this defendant and this co-defendant that were unidentified. And so we would ask for 10 years.
All right, the court is going to find you guilty, and each cause number, the court will sentence you to a $2,000 fine. Time and money to run concurrent. Court will give you credit for any time served. The cases will run concurrently. Court will take in consideration 2025 CR 001801A, 2024 CC 741988. There's an affirmative finding of deadly weapon. The court will request the therapeutic community. Court will sentence you to 7 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. I understand that prison life is extremely hard. If I had all of the money in the world and could build a prison the way it should be built, every inmate would have their own cell. That wouldn't be 4 to a cell, 5 to a cell, or any of this. But I understand that there are bad things that happen at the prison. But here's the thing. Do not waste your time at the prison. There's some free education there. Make sure you do that. If they have a welding program, get in a welding program, and do not become institutionalized. And do not get tattoos all over your body, because people will recognize those as prison tattoos. When you're released from the prison, if you have any problem finding a place for any alcohol issues you have, any mental health issues you have, if I'm still here, you come back here, I'll pick up the phone and find transitional housing for you. All right, good luck to you. Okay.
I would very much like to believe that in the next 7 years that young man will get things sorted out. I think it is more likely, however, that especially given his age and the fact that his brain will finish developing behind bars, I think there's a greater opportunity for him to be a lifetime criminal now. And that is unfortunate. I hope I'm wrong. I really do. I don't think I am, though, but we'll see. That brings us to the end of the day. I actually had so many other things queued up, but today flew by. Some good hearings, some heavy ones for sure, but I hope you all enjoyed it. I know I did. I said it before. I get myself up super early every morning to spend this time with you because it's the best thing in the world. I love it, and I hope you guys do too. So we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members, so join us for the pre-show. This morning's pre-show was a little bit heavy, but who knows? Maybe tomorrow will be the same. I have no idea what we'll talk about tomorrow, but we'll figure it out. But go have yourselves a great Monday. Look forward to seeing you all again soon. Take care. God bless.